ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. I welcome all to the second session of the second day of 3 days workshop on Capacity Building Orientation Program on New Criminal Laws 2023. Well, it reminds me one of the quote of former Indian President Dr. APJ Abdul Kalam, who said, "The purpose of education is to make good human beings with skill and expertise. Enlightened human beings can be created by only teachers." Today, we have a teacher here who has come to enhance our knowledge. I am honored and privileged to introduce to you all distinguished resource person, Mr. Shubham Srivastava. Mr. Shubham Srivastava obtained LLB degree in the year 2014 from Faculty of Law, University of Lucknow, Uttar Pradesh. He has obtained LLM degree in the year 2015 from Nalsar, University of Law, Hyderabad, Telangana. He is pursuing PhD in Nalsar, University of Law, Hyderabad, Telangana. He has teaching experience of 8 years. From April 2016 to January 2018, he worked as Assistant Professor Law, College of Legal Studies, Dehradun, Uttarakhand, and presently is working as Assistant Professor Law, University of Study and Research in Law, Ranchi, Jharkhand. He has co-authored books with Dr. Anjani Kant in law relating to women and children and Mahila Ivum Bal Kanun. Presently, he is editing volume on the new 3 criminal laws with special reference to contemporary issues and challenges. He has authored several articles on various law subjects. Notable articles of Sir is on media and trial and gender discrimination and the offences which is hunting in India. He has delivered several lectures on the new 3 criminal laws at BR Judicial Academy, Police Department and to the Forest Department, Ranchi, Jharkhand. He has also delivered lectures on Domestic Violence Act 2005 for public prosecutors at Judicial Academy, Jharkhand, and on POCSO Act 2012 and JJ Act 2015 to the Child Welfare Police Officials, Ranchi, Jharkhand. He has taken part in several international conferences and presented paper on law subjects. Notable achievements are presented paper on juvenile delinquency and protections of children from criminal norms in Romania, presented paper on empowerment of women in India, role of judiciary in the national seminar sponsored by UGC. Presented paper on women and the law, legislative actions to what extent affirmative in the national seminar. He has given live address on new 3 criminal laws in Doordarshan, Ranchi, Jharkhand. He has also taken part in several orientations, refresher, workshops and training programs related to law subject. I, on behalf of Karnataka Judicial Academy and all the participants present here, heartily welcome you, sir, to our Karnataka Judicial Academy, a temple of knowledge, with a big round of applause.
Thank you, sir.
I request sir to grace us with his insightful thoughts and enlighten us on Bharatiya Nagarika Suraksha Sanhita 2023 with special reference to provisions related to FIR, investigation, arrest, remand and bail with special reference to Satyendra Kumar Antil vs CBI and Arnesh Kumar vs State of Bihar, and provisions and reforms related to proclaimed offenders, trial in absentia, evidence of public servants, experts. Over to you, sir.
Thank you so much, sir. I would rather stand and then speak. Thank you so much, sir, for such a detailed introduction. It was not required though, but thank you so much for inviting me to interact with you all. Recently, I believe, thank you. You all have seen there have been a lot of voices around the new criminal laws, its enactment, its constitutionality, that the provisions have been widely drafted, the penal law, like the Bharatiya Nyaya Sanhita. Then there have been voices around the BNSS, that the Bharatiya Nagarik Suraksha Sanhita, that it lists down certain rights of the victims, rights of the accused, then detailed procedure about investigation, trial and other things. Then you would have heard about the new things like upgradation or what you call it, involvement of technology at the time of investigation, trial, prosecution and everything. Then you would have also read about the Bharatiya Saksha Adhiniyam, which lists down the what evidences are admissible or what things are relevant before the court of law. And then you would have also heard about the Section 65B certificate that was required in the Evidence Act earlier. Now that is in section 63 and a format is prescribed. So what attempts have been made through these three laws is to simplify the procedural aspect, give certain rights specifically, like, though there were judgments existing which had mentioned earlier also that no, these are the rights of the victims and the accused people. So this entire exercise by the committee which was constituted by the Ministry of Home Affairs has been to consolidate and amend the law. If you read the preamble also of the three laws, it's the same thing, that consolidate and amend the law relating to evidence, procedure and the penal law, like that. Okay. So we have, let's say, around 8 hours of interaction today and tomorrow. So instead of rushing with the provisions, I would just like to have a casual interaction first, and then we will move on to the detailed provisions in some time. Okay. So you all understand that the penal laws that every country, civilized country has, is supposed to be just, fair and reasonable. And that also flows from Article 21 of the Indian Constitution, that no, if any person is to be deprived of the right to life and personal liberty, there has to be a just procedure. Likewise, we have penal laws, Bharatiya Nyaya Sanhita, that lists down the actions which constitute as an offense. And if someone does an act which is against that statute, some punishment is prescribed, right? You'd have also gone through several sessions earlier wherein the constitutionality of having a detailed provision or a broad provision in a penal law would have been discussed. A few things I just want to add here. When we look into the penal laws that we have in India existing right now, the Bharatiya Nyaya Sanhita is a new development. Like, it has mentioned new offenses like organized crime, then petty organized crime, then the punishments are added therein. So if you go through the entire scheme of the BNS, you would see that at several places either punishment has been increased, this is one thing, or secondly you would see the provisions have been broadly worded in such a way that maximum people could be brought within the ambit of the penal law. This is one thing. The objections that any civilized nation faces which drafts or comes up with a new penal law is majorly that there are something. Okay. Achha. So major challenges these civilized nations face when they come up with new laws or penal laws is that there are certain cardinal principles of criminal law. I'll not try to bore you, but I'm just trying to give you an outline or the background so that these laws should be understood in this light only, right? So any penal law or the penal laws have certain cardinal principles like presumption of innocence. You know this. There should be a strict interpretation of the penal laws. The penal laws, like you would also have, since you are law experts, you would have also read the subject on interpretation of statutes. And one of the primary or the main fundamental principle therein is the penal laws, when you look into the rules of legislative drafting also, you would see that penal laws should be narrowly drafted so that maximum people stay out of the penal zone. The idea of any civilized nation is not to penalize. The idea is to save people from criminality. Am I clear? The idea of any civilized nation is not to penalize people, but to keep maximum people out of the domain of the penal laws so that they do not become criminals. They are not tagged as criminals. Instead, they are civilized citizens. So penal laws serve two purposes. One, to deter people who are thinking of committing crime, and second, those who have already committed crime, to try them and punish them. But trial and punishment would have an implication on personal life and liberty that is protected by Article 21 of Constitution. So there need to be a just and fair procedure. And that gap, this just and fair procedure, is being filled by Bharatiya Nagarik Suraksha Sahita. Right? And this BNSS, again, has to comply with the fundamental principles of criminal law because, see, any consequence of a criminal trial is the compromise on the personal life and liberty of an individual. So penal laws should be narrowly drafted. They should not be broadly worded. Second, punishment should be proportionate to the nature of and the gravity of the offense. So this thing has to be kept in mind. Third thing, there has to be a presumption of innocence. Person should not be presumed guilty unless he is proven to be so. Right? So generally, what general laws we have in India, we protect this kind of principle. There are only few statutes like POCSO, presumption of culpable mental state, NDPS, presumption of culpable mental state is there because these are the crimes which the state considers to be of such a grave nature that no, which can't take any kind of chance in this situation. And it is difficult to prove these things because these things mostly happen in private. So if you remove this thing, it will be difficult for the child to establish in the court of law, right? But again, there are so many judgments coming in from the Supreme Court which says that no, the primary burden is always on the prosecution. Even in the POCSO cases, even in the NDPS cases. Though we are presuming it, but at the same time, the primary burden is always on the prosecution that you have to discharge the initial burden that the accused person committed the offense. And once this burden is discharged, then only the onus shifts on the defense side that he did not commit any such offense. Bharatiya Nyaya Sanhita has followed this principle. It nowhere mentions that there should be a presumption of culpable mental state. So we are assuming that this law is constitutionally valid. Right? Second thing, proportionate sentencing. Proportionate sentencing is again a debatable topic. For someone, as an individual who commits a crime, he might think that no, I did not commit crime with such grave intention. I should not be punished or given this much of punishment. While with respect to state, it must be a different thing. Because state is the victim. यहाँ पे क्या बोल रहे हैं? Like, okay, so there's a possibility that I might use some Hindi phrases because of the belt I'm coming from, but I'll try to avoid such thing. What this provision is saying, see, presumption for state might, see, every offense is against state only. A state might think that what you have done is grave. For me, it is grave. And when we talk about criminal justice system, in justice system, it is not just giving punishment to the accused person, not just giving remedy to the victim. It has much wider perspective. The wider perspective, if I try to define in one line, is giving one his due. Giving one what is due for him. For an accused person, he should be punished. One who has committed the offense, he should be punished. This is what is due for him. For a victim, what is due for him? Justice. It's a remedy, some compensation, some relief, or if possible, if he or she could be restored to the original position, try to do that. And that is why we have courts having extraordinary powers, inherent powers to do complete justice like that. And then a state comes in, says that, no, justice, we also define justice. And for us, see, we have been a British colony, and one of the famous common law principle is parens patriae. Parens patriae, it's an English Latin phrase, P-A-R-E-N-S, parens, P-A-T-R-I-A-E, patriae, which means a state is the father of its citizens. A state is the father of its citizens, and father is always protective. Parents, they are protective. Even if you cause some little harm to the child of some person, that person will become furious. Like, how could you do this thing to my child? Even if the harm that is caused to the child is of not so grave nature, but the scold that you get, how you are scolded by the parents, is disproportionate always, because parents have to care, and the same principle we have imbibed in India also. We are working on the same principle. So we will decide what punishment is just and fair. This could be one interpretation. If we want to save the laws that come from the government or the state in which we are living. I hope I made myself clear to all of you. Right. So this is about the BNS. Moving on to BNSS. Now the criminals, people are using different ways of committing crime. They're adopting new. I'm coming from a state, Jharkhand, and if any of you would have had the opportunity to watch the Netflix series of Jamtara, you know what Jamtara is about. So lot of technology, fake calls they are doing, right? So that place is in Jharkhand only, right? So people are adopting new ways of committing crime. And those who could not have the opportunity, please do watch. And if you do not understand the language, it has subtitles also. You can read it and understand. These people are adopting new ways of committing crime. And these new ways are such, what you call it, advanced, that our procedure is falling short of catching these people. So we need what? We need to upgrade ourselves. We need to upgrade ourselves so that these people who are adopting new means of committing crime, we are at least at par with them. We can at least try to catch hold of them, prosecute them and punish them. And this is what the new 3 laws have tried to do. The BNSS, you would see at every place, in every trial or every case wherein you want to punish someone, you would want concrete evidence, right? Without evidence, nothing can be done. So if you want good evidence, you need to empower the police. The police, the one who is collecting evidence. Police with the help of forensic experts, now the new law says, right? So every place you see, use of technology is promoted, is suggested. And several places it is mandated also. Like recording through audio-video means. Then at the time of filing of the FIR also, you can lodge the FIR online. Like that, I'll discuss these things in detail now. So this is there. Then trial in absentia is there, because these criminals might stay forever out of the clutches of law, might not turn up before the court of law, right? These could be there. So technology is, use of technology is promoted. Then you look into Sakshadiniyam. Sakshadiniyam is what? Again, they have done least changes in the Sakshadiniyam, because nothing was required much. The only thing that they have tried, because whatever Sir Stephen, the father of Evidence Act, framed, is so foolproof that they could not even required or did any changes. Major changes relate to electronic evidence only, that how to use it. Technologically advanced gadgets may be used, like that, these things are there. Certificate thing is more simplified, like that, right? So this is the entire background of the 3 laws. Now we'll proceed further. We all understand that if the investigation is proper, see, every criminal justice system, as I say, justice means to give oneself his due. It has 2 perspectives with respect to punishment. One, the one who committed the crime should get punishment, and the one who did not commit crime should be set free. Yes or no? One who did not commit crime, one who is innocent, he should not get any kind of punishment. This should be the idea. And this we can ensure in today's time with the help of technology. With the help of technology, we can at least try to an extent, ensure that an innocent does not get convicted, and one who has committed the crime is not set free, like that. Okay. So what we are doing now, we are trying to bring in or take the help from forensic experts. And the new law is now mandating that in every case wherein the punishment for the offense is 7 years or more, forensic investigation should be mandated. And the state governments are given 5 years time to develop the infrastructure, because we are lacking the number of FSLs that would be required even today's time, 2-3 years of waiting period for testing a sample and then giving the proper report. So a lot of things need to be done. So 5 years time is borrowed for this purpose only. But you see, the forensic science has its role to play, and we cannot dispute that if we involve forensic investigation in any criminal matter, if it is part of the mandatory investigation procedure, we can at least try to improve the nature, the quality of investigation that we do, 1. 2, we can try to improve the quality of evidence that we collect. We can try to improve the quality of evidence that is preserved in its original quality, and then produce it before the court of law for proper appreciation, admissibility, and then coming to the decision. Right? So these things are there. Now let me proceed with the provisions of the BNSS. These are the major topics which I would try to cover in today's session. Criminal justice system, we discussed about lodging of the FIR, then investigation, filing of police report, prosecution, trial, and sentencing. Right. Role of forensic science, the judgment was there, Dharamdev Yadav versus State of UP. In simple terms, there have been judgments, voices from the Supreme Court also, that judiciary, prosecution, investigation, all need to be, the 3 stakeholders, primary stakeholders, need to be strengthened with the help of forensic investigation, with the help of forensic science, so that the one who has committed the crime cannot get the advantage of the age-old system that we have been following. So there have been a lot of voices, and the same thing now the new law tries to incorporate in the provisions which are listed herein. First, information report. Okay. You all know about the Lalita Kumari judgment, preliminary inquiry thing, and the law as was existing under 154. Let me just give you an overview. The earlier law, as it used to mention, is, or even the present law, that police shall lodge the FIR in a cognizable case when the information discloses the commission of a cognizable offense. Information discloses the commission of a cognizable offense. And this is very subjective. Who will decide whether information disclosed the commission of a cognizable offense or did not? The police might say, and every person is not a law student or a law expert. He might not know the technical terms that are used in the penal laws. He might not know what offense has been committed, the name of the offense I am talking about. He might not know the provisions. And he might be under a lot of trauma, pressure, and everything, that he might not be able to disclose clearly that what actually has happened with him or someone who is known to him. So he might come to the police station, give the information. Police might say, I do not understand what you are trying to say. And I do not believe that what you are saying amounts to a cognizable offense. So police might refuse to lodge the FIR. This problem is there. Earlier used to happen the same thing. So Lalita Kumari judgment says, if you are unable to decide, and at the same time, see, there could be 2 things. One is the police officer is deliberately refusing to lodge the FIR because he's saying, no, it is not a cognizable offense, I will not lodge the FIR, I will simply make an entry in the station diary and ask you to go. This is one possibility. Other possibility is police officer might be genuinely confused, if he is acting with all honesty, that there is a cognizable offense or a non-cognizable offense. If it's a COG case, let's say, and the informant is unable to clarify properly in clear terms that it is a cognizable offense, then police officer should not stand still there. police officer should go on field, investigate, do some inquiry, preliminary work, be sure whether it's a COG or a non-COG case, and then take proper action. This is what the Lalita Kumari judgment says. But Lalita Kumari judgment had some limitations, like in every case preliminary inquiry is not mandated. In certain offences only, like matrimonial offences, financial offences. So like that, limitations were there. And the scope of the inquiry was limited to finding out whether a cognizable case is made out or not. Beyond that, nothing was required. But now under the new law, I'll discuss in detail, the ambit of the inquiry is widened. So not just the penal laws, that there are laws of vices, ki BNS ke provisions have been broadly worded. It is the BNS's also provisions have been widely worded. Now the scope of the inquiry is so widened that the police has to find out whether a prima facie case is made out or not. What is this prima facie case? It could be interpreted very widely. First thing, to be sure that a false case is not registered, or a fake information is not given, or an information is not given just to abuse the process of law, like that. An information is not given just to misuse the process of law to the disadvantage of the other person. It may have several interpretations, several implications. So the law is now widened. The court, the police has to go and check that whether a prima facie case is made out or not, and not just about cognizable offense. All offenses for which punishment is between 3 years to 7 years. Because in a cognizable case, you have to lodge the FIR. It is mandatory. It is not optional. But there could be a possibility that you are not sure. The law is not assuming that you are not acting with honesty. Law is assuming that you are acting with honesty and you will lodge an FIR in a cognizable case. And when it is non-COG case, or you are confused, 3 to 7 years punishment is there, you conduct preliminary inquiry. This is mandatory now. Information. See, what problems are there? Information relating to the commission of a cognizable offense irrespective of the area where the offense is committed. This is the new thing. Zero FIR, which was existing, right? The government order was there from 2015. Ministry of Home Affairs, you would be aware that a government notification was issued directing police officers to lodge the FIR in cases relating to offenses against women, right? Now this has got a statutory recognition. This has got a statutory recognition that irrespective of the area where the offense is committed, police should lodge the FIR in every cognizable offense. That concept of preliminary inquiry still remains everywhere, right? Irrespective of the area. So some person who is traveling, let's say through train or some other ways of transportation, something is lost, let's say theft happens, some harm is caused to him, he may simply get down at the police station, which is nearby, get the FIR lodged, or he may reach the destination, there also he may lodge the FIR. This is one thing. Second thing, which section 173, which was earlier 154, it says is about the manner in which an information can be given to the police. You would be aware of the Jessica Lal murder case. Jessica Lal murder case, there have been several calls made by from the place wherein the offense took place. Court came with the finding that no, this making a phone call does not amount to lodging of the FIR. Will not count the time from that time, right, when the call was made. So the law is now clear. Any information given through electronic communication amounts to lodging of an FIR. But this statement by electronic means is qualified by the use of certain words. It shall be taken on record by him on being signed within 3 days by the person giving it. It shall be taken on record by him on being signed within 3 days by the person giving it. That means that police will not lodge the FIR immediately once he gets the call. He has to wait for 3 days, get the signature of the informant, then only it shall be taken on record. Am I able to clarify? The provision that is saying, if the person, see, in the first line itself, clause 1, FIR can be lodged by 2 ways, orally or through electronic means. Through orally, person has to go to the police station, get the FIR lodged, and see the last line, shall be signed by the person giving it. Clause 1 says, it shall be signed by the person giving it. That means there has been a lot of emphasis on signing, signature by the informant. This is one thing. But if the information is given electronically, then person might not be available for signing it. And an offense, and there may be circumstances wherein a person might not be willing to come to the police station. This is one thing. And there could be physical impossibilities. That person is not in a position to move to the police station. Third possibility, the person is traveling, he is in some other place and he can't travel back to get the FIR lodged physically. Then again it's a problem, right? So he can give the information electronically and the signature can be taken within 3 days. But it says it shall be taken on record on being signed by the police station. That means police can't start an action unless it is signed by the informant, right? But this is the gap. Police will say, see, it is for the advantage of whom? The public. Public, because of these possibilities, might not come to the police station. And then if the police says, you have to come for signing it, then only we'll proceed, otherwise we'll not proceed. This is one possibility, right? But then there are judgments which can fill this gap, 1. 2, you may see the last line, and the substance thereof shall be entered in a book kept by such officer in such form as the state government may prescribe by rules in this behalf. That means power has been vested upon the state governments to frame rules to fill this gap. To fill this gap, right? Now, if you are aware, like see, the provision also says it, all the state governments are coming up with their rules. Few state governments have prepared it, few are still in the process of preparing it, right? This gap needs to be filled because the provision is not clarifying that, it is not distinguishing that for these nature of offenses, you have to come to the police station, and for these petty offenses, you can give the information online. It is not saying like that. That means this provision can't be interpreted in this manner that only for grave offenses we would take it online, or only for petty offenses we would take it online. Am I able to clarify? I'll repeat again. The provision is not clarifying that we will take electronic information or accept electronic communication only for petty offenses. It is not clarifying. Then there could be a possibility that heinous offenses might be reported through electronic means. Let's say an offense is committed against a woman, right? 65, 66, 67 BNS, the new laws. Some offense under POCSO Act is committed against a child. Whom do he approach? The best option or the safest option and the immediate option he can think of is call the police, right? If a person is staying in his house, enjoying his company, and then let's say that person is being surrounded by tens and fifties of dacoits, a gang of people, what will he do? No, wait, I'll go to the police, lodge the FIR, then I'll come. No. The safest thing is call up the police for help, and then the police will say, no, we have to come for signing it. Did you get the point? So this gap is there that needs to be filled. And see, for the same reason, if you go through the BPRD manual that has come now, it is not exhaustive one, they are just trying to update it. We may distinguish between petty offenses and heinous offences. For offences which may require immediate action, police cannot say that for 3 days I will wait for you to come and sign and I will not take action. It will defeat the purpose. We, as a student of law, we all understand that every law has a purpose behind it. And that law is enacted to serve the purpose. Law is not enacted to defeat the purpose. And when we interpret it, the interpretation should not be that the provision is defeated, right? So it will defeat the provision. So 2 classifications. For offences which require immediate action, police should reach the place of occurrence and take immediate action. Police can't insist for signing of the FIR by the complainant or the informant. And for other nature of offences which may not require immediate action, they may exhaust this or wait for this 3 days time and ask the person to appear, to come. This is one thing. Other thing, what will the police do? If, let's say, police needs to take immediate action and the informant cannot come to the police to sign the FIR, what will the police do? How to proceed? Again, there needs to be some clarity. Should they lodge the FIR as a self-statement that they got the information, they did preliminary inquiry is already there, right? They did primary investigation and preliminary inquiry. They got to know that there is a genuine case made out. They can simply make a self-statement and get the FIR lodged. The receiver becomes the informant. The receiver of the information might become the informant. So this manner, gaps can be filled and purpose can be served of the provision. Am I clear? Any doubts with respect to this? Okay. Now this is one thing. I referred to one judgment from Andhra Pradesh. 0 FIR, though it came in 2023, will be enforced from 1st July 24. There have been judgments coming from Supreme Court also, wherein courts have said that there is no problem. If you lodge the FIR with a 0 number, send it to the other state. These things have been done since long time with respect to other things, like when you have to require some search in the other state, when you have to require some investigation in the other jurisdiction, you do these things. So likewise, this could be done. But now, since it has got statutory recognition, it will be followed. There is no problem now. Now, this NCRB has also come with the new format. Have you seen that new format of 0 FIR? No. I have that. I'll share. I'll share with you. I do not have in the slides. I have it in a PDF file. So these things are being done, and the rules are being formulated by the state machineries. Now see, this thing is there, wherein a sexual offense is committed, mentioned in 64 to 71, 74, 75, like this. Then information shall be recorded by a woman police officer. Here it says, committed or attempted, then such information shall be recorded by a woman police officer or any woman officer. This is mandated by the new SOP that has come from the government now. So in every case, this needs to be ensured that information is recorded by either a woman police officer or any woman officer. Right. The next thing that we have to look into is how we can incorporate or help the victims. Because see, there have been a lot of problems with respect to these things. A person comes to the police station, gets the FIR lodged. The hurdles are, police might lodge the FIR, police might not lodge the FIR. This problem is there, right? Then at the same time, person might not know what is the status, whether FIR is lodged or not. How would I know? Unless I get a copy of the same, how would I know that that the FIR is lodged? The police might simply give some document to me like that. So it says, a copy of the information as recorded in the subsection 1 shall be given free of cost to the informant. Now, victim is also added. So informant might come, victim might not come. Victim might come, victim is the informant. So whatever is the situation, in that case, a copy of the FIR needs to be given to that person. One thing I'm just reminded, I forgot to mention earlier, this thing is there. By electronic communication, it shall be taken on record by him. Now, this electronic communication, what is the mode of electronic communication? That is not clarified, right? So that is for the state governments to mention specifically what mechanism they would be following. One possibility is the state governments come up with their own website or mobile application. Through that mobile application or website, an FIR can be easily lodged. Information would be sent to the concerned SHO, and he can proceed with the investigation. This is one possibility. The other possibility is the most handy thing that we have in present time is mobile phone, right? And approximately, I would assume that everyone would be using WhatsApp or some other way of communication, right? WhatsApp could be used, some other messenger could be used, email ID could be used, normal text could be used. All these things could be used to give the information to the police for the purpose of lodging the FIR, right? If you go to the portal, like Jharkhand also has an FIR portal, state government has already started this long back, right? You simply mention that is control. See, it is possible like people might assume, abuse it. So it is to be connected with the mobile number, OTP is to be sent, that OTP needs to be mentioned, then only you can lodge the FIR. So that ways, connectivity could be established between the informant and the FIR, right? So even if you want to, like what the portal is like the name, place of incident, date, time, then there's a description about what actually happened, you describe that in detail, and then there could be a possibility that the signing thing, it needs to be signed, no. Person may be asked to upload the signature, simple. You sign on a piece of paper, take a snapshot, upload it. That's what we are doing for different things, other things also. So the signing problem could also be solved with this kind of, mechanism, right? Okay. The preliminary inquiry thing that I was referring to is there in subsection 3 of 173. This provision has a lot of implications and lot needs to be done in this area. It says that without prejudice to 175, that is a different thing, on receipt of information relating to commission of any cognizable offence which is made punishable for 3 years or more, but less than 7 years, the officer in charge of police station may, with the permission from an officer not below the DSP, considering the gravity and the nature of the offence, proceed to conduct preliminary inquiry to ascertain whether there is a prima facie case. See, the ambit is widened. Ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days and proceed with the investigation when there exists a prima facie case. Now, one problem that will arise here is may. Use the term may with the prior permission of the DSP. Is it obligatory? Is it not? This is one thing. Police might try to send the other person. One who has approached the police to get the FIR lodged, police might say that, see, it's a long due procedure. I have to take permission from DSP, so it will take time, right? This is one thing. Second thing, what would be the manner of taking this kind of permission? Should it be in writing? Should it be oral? If it is oral, DSP might later on say that, see, I did not give any kind of permission. Court will ask the police, did you take permission from DSP? Police might say, it says may. I did not go for permission. See, if there is a false case made out and the police is colliding with or working with some external factors, right, then this question will definitely arise. Why did you not take permission from DSP? Why did you choose this method of taking permission? So there are a lot of gaps herein. Practical implications would be far very far, right? So there are gaps which need to be filled. One thing. Second thing, if you have done preliminary inquiry, what is the end result? How to find out? How to be sure? Because see, this is in a provision, and when the case comes to the court has to look into it. You did the preliminary inquiry, you could not find out this thing. We as judges can openly see, case might also come to you as a complaint case, right? And in that complaint, person might specifically mention that these things have happened. So there are many possibilities which would crop up with respect to subsection 3. Now, when the police SHO takes permission from DSP, that permission needs to be documented. If it is documented, then there is a proof to suggest, to show that something was actually done after the receipt of the information. And you would also have the opportunity to examine what information came, what matter was sent to the DSP for, because you might receive something and you might communicate something else because you do not want to do. And DSP might say, do not investigate. If he says, do not investigate, now I am happy. Because I do not want to work, I don't want to work. Like that. So documentation should be there of the information being received and information being sent, one thing. Second possibility, I as an informant go to the police, get the FIR, to get the FIR lodged, police might say it's a long due procedure, right? Matter is sent to DSP. How much time will the DSP take in giving the consent? How much time? The law does not prescribe it. So again there is a scope. So this gap again needs to be filled. In how much time police will send the information to the DSP? Do I need to send it today, tomorrow, day after, when? Or before sending it, do I need to conduct preliminary inquiry to find out whether the information is false or not? See, there's a lot of implications. First thing, information being received by police should be sent to the DSP on record, right? Immediately. It may be mentioned that within 24 hours you have to send it. Like we mentioned, no? You have to produce the arrested person before the magistrate within 24 hours. You do it within 24 hours. This is one thing. Second, you document whatever information you received and whatever information you sent. Second thing. Third thing, DSP should also maintain a record that he got the information on this particular date, this particular time, and how much time he took to give the decision or to give his consent or to give the permission, right? That record needs to be mentioned. You get the point? So, you see, that will now allow the court to have a complete information of what was actually done. Now there could be a possibility, again another possibility, I give the information to DSP, DSP allowed me to investigate, do the preliminary inquiry, I did it for 14 days and I am not able to come up with any conclusion. That's a safe way, no? I did preliminary inquiry, I could not find anything. What should I do now? So now the government is prescribing departmental inquiry. Departmental action against the police officers who are not able to conduct preliminary inquiry within the period of 14 days. Right? And you just need not have to conduct investigation, complete it for the sake of formality. You have to mention specifically what are the findings of the inquiry. What did you actually do? See, it's a dark space. You are the one doing it, how would the other person know? Right? So you need to document specifically what did you actually do to find out that something is made out, something is not. Right? So what is prescribed now is a separate register for preliminary inquiry to be maintained by two authorities. One SHO level and the other is DSP level. And the format is to be prescribed by the Director General of Police, DGP. This is mandated. SHO has to maintain a register in which he'll mention information received, the details, what did he do, whom did he interact, the entire detail of the inquiry. And then it should be one record to be maintained by the DSP. He would mention what thing is there, what is there, and how much time he took. He has to give the consent within 24 hours. The DSP also has to communicate the consent within 24 hours to the SHO to conduct the preliminary inquiry. And if, let's say, there could be a possibility that the DSP is occupied, he is not getting time to look into the matter, so he might not be able to communicate, right? So in such cases, this is for you to take into consideration. See, police might say, I am waiting for the consent. DSP is occupied. They might say that I am waiting for the consent, I have still not got the permission, what should I do? No, you have to take action. In cases wherein you do not get the consent from DSP within 14 days, because see, the deadline is 14 days only. In these 14 days, and this 14 days shall not be counted from the date of consent, no. This is 14 days from the date of information received. Whatever formalities you are doing in-house, that is not the worry of the person who has come to give you a complaint, right? So if within 14 days this entire procedure is not done, police shall, not may, shall proceed with the lodging of the FIR. Did you get the point? Separate preliminary inquiry register by SHO, separate register by DSP. Details, each and every details shall be documented in the diary, in the register. A brief entry of the same shall be made in the station diary. दोनों में करना है. In both, they have to make the entry. In the station diary, brief information should be mentioned. In the preliminary inquiry register, detailed information should be mentioned. And then, within 24 hours, the SHO should send the information to DSP. Within 24 hours, the DSP should give the consent to the SHO, and SHO should proceed therewith. If this thing could not be done, entire thing could not be done within 14 days, then police shall lodge the FIR. If these things do not happen, the SHO is not able to lodge the FIR, one thing, SHO is not able to complete preliminary inquiry within 14 days, then departmental inquiry shall be initiated against the concerned police officer, right? Besides this, some responsibility has also been vested on the SP, Superintendent of Police. In the monthly review meeting of the crime report, they have to check how many preliminary complaints came, how many preliminary inquiries done, what has been done, and if there are correctional measures required, they can take it at their level. Right? Am I clear? Yes. Yes, definitely. See. Right. Just to clarify further, now then you may get the answer from my thing. See, the law very well makes it clear that this 14-day period, just listen to me please, 14-day period is just suggestive. You cannot say that I will wait for 14 days to get the FIR lodged. It's the maximum limit. So if you get the information, see what the second clause says, proceed with investigation when there exists a prima facie case. So maximum time is 14 days. If you can complete this thing within 1 day, you proceed. So again, see, these things are open to challenge. The informant, if the police is not doing it, when the case approaches the court, these things may be brought on record, that this thing is deliberately being delayed, or it was delayed deliberately for 14 days so that the evidence is destroyed. Definitely. This delay in lodging the FIR is very, very subjective. what actions have been taken, you have to keep on record if you want to justify that you took this much time because this was required. And see, one more thing, just to clarify, you will get the answer in this last line. The term used is may. The term used is may. That means police need not send every case for preliminary permission from the DSP. Police need not send every, see, this is saying may. So it should not happen that in every case 3 to 7 years punishment is there, you are sending it to DSP for consent. No, it can't happen. This is may. That is why the preliminary inquiry register that I am talking about, it also needs to mention the reasons why preliminary inquiry is required. Why preliminary inquiry is required? It might not be required. You got the information of a cognizable offense, you lodged the FIR. That's what the law says, right? So if you require preliminary inquiry, you mention specifically the reasons and the grounds for the same. And at the same time, let me clarify, the DSP is maintaining a register. He also needs to mention why this particular case is fit for preliminary inquiry. You get the point? So when you are calling for these diaries during the stage of trial or during the stage of production of these documents before the court, you also can take or ask necessary questions. And that is why for the same thing, SP is being asked to conduct review meetings of these preliminary inquiry registers to find out that, see, every case should not go to DSP for permission or consent. In what manner? That's what the provision says, may. Police may send, police may not send. If you are sending, mention reasons. If DSP is allowing it, mention reasons. If DSP is rejecting it, mention reasons. Or DSP may simply direct him, do not conduct preliminary inquiry, lodge the FIR. In those cases, see, I get your point. I get your point, because in such cases, IOs may try to put the burden on DSP. This possibility is there. This possibility is there, which is why register you have to maintain. If there are cogent reasons, why are you sending for preliminary inquiry? You have to mention. So at least the courts have the opportunity to review those things and pass necessary actions or orders whenever required. No. The red thing that I have mentioned is for you, my comments.
It's your comment.
That's my comment.
Not in the act.
No, not in the act. See, okay, just to clarify, everything that is highlighted with yellow is a new provision, is a new amendment. And that is written with red ink. That is my comments. Okay? Okay. So that's why I mentioned, in every case, such permission may become mandatory because the SHO or the IO might try to put the burden on the DSP. So for this thing only, these review meetings by SP would have some impact on this kind of abuse, right? Then see, one more thing. Complaint, you all know. First, go to police, get the FIR lodged. Now the possibility is, you have more powers, like you may simply lodge the FIR online, open the website, get the FIR lodged, and you need not go to the police station for the purpose of signing it. Because what? 15 years, a male child below 15 years should not be called to police station. Women of any age shall not be called to police station. Any person above 60 years of age shall not be called to police station. Person who is ill, mentally or physically, or suffering from some kind of infirmity or disease shall not be called to police station. That means for the purpose of signing it, police has to go to their place of residence or any other place for the purpose of getting the signature. right? So the law is now simplified. If these things are not happening, you can approach SP, Superintendent of Police. If even that is not happening, so now earlier the law was not clear. This is again open to interpretation. Whether I have two options, first to lodge the FIR, or second to approach magistrate. Either of the two is there, or if one fails, then only second should be exercised. Did you get my point? Earlier, the confusion was, should I exercise the first option first, that is approach the police? If it fails, then approach the magistrate. Or do I have the right to simply send a letter to magistrate? I do not want to go to the police station, right? Now I believe the law is clarified. First, you need to exhaust the first stage, that is approach the police. If that is not working out, then approach magistrate, because see, a new term, failing which, has been added. Failing which, that means police, SP, not working out, failing which you may send a complaint to magistrate. Right? Now, I hope this 173 is majorly clear? Right. Now, there are few things I also want to mention.
Hello?
Yeah.
Sir, the information shall be recorded by police officer or any officer. What is it means? Police officer is okay. Woman officer, what it may be? Who is woman officer?
Woman officer may be a civil officer. If woman police officer is not available, some officer, woman, working in a public sector, government organization, may be called in his presence or in her presence, information may be lodged.
Destination, if doctor or other officer will be...
Yeah, that qualifies. That qualifies, and same thing applies to magistrates also. In cases wherein a sexual offense is committed, the information, a statement, that 164 statement, you remember? That is now 183. So if an offense relates to of the same nature, a statement shall be recorded by a woman magistrate.
How it can be recorded? It may be recorded open court or superintendent of police or any other...
No, these things are to be kept in private.
Yes.
In camera. And see, if women magistrate is not available, then again help of a civil women officer may be taken. So law is same for both police and magistrate.
Yes, sir.
Okay. A few things I just want to mention again. There could again be a possibility. See, the maximum issues that would be coming before you, I believe, would be with respect to lodging of FIR or with respect to investigation in the new law, right? If, let's say, I wrote a letter to the SHO that this thing has happened. Let's say I'm traveling abroad and some group of dacoits rob my place of residence, destroy everything. What should I do? Should I come back? No. I may write a letter to the SHO and I may send a WhatsApp or an email. I can't come for signature also. What should be done with this kind of record? What I sent is also a record. It's also a record. Should it be saved? Should it be destroyed? Should police, on the basis of this information, record a self-statement FIR and then proceed? No. No. The record that I have sent, the rules are mandating that you have to save a copy of this in the police station desktop or computer. Whatever electronic device that you have in the system, in the police station, you have to take a record of the same and save it in the system. And then if you are proceeding to lodge the FIR, the name of the file should be mentioned as if the name of the FIR, complainant name, etc. like that. So this also you have to keep in mind when such kinds of things are happening, because when you are allowing public to lodge FIR irrespective of the jurisdiction, irrespective of the area in which the offense is committed and irrespective of the area in which you are living, right? Then there is going to be a tsunami of complaints coming through this mechanism. Because you are not barring me from using this kind of mechanism. I can simply WhatsApp you. And if you do not proceed, I'll send a complaint. You get the point? And see, there has been a lot of, I have been involved in training of more than thousands of police officers and judges, and I have experienced this kind of attitude that they are still not ready to accept that I have to lodge the FIR just on the basis of a WhatsApp. Just on the basis of a call that I get, I have to proceed. They are not ready to accept this. It will take time. And see, it may happen with the senior level police officers, they can understand. But the junior level officers, they might not understand. And there are still police stations, small police stations, wherein you do not have a senior rank official. Am I right? So this is the thing that you have to keep in mind, that they have to keep the record of the information that they receive, because it may happen, they received a different information, they lodge a different information. Did you get the point? I might send that it's a cognizable case. They might see that it's not a cognizable case, or the nature of offense is different. So the original record needs to be preserved, right? I'm proceeding further now. Information for a non-cognizable offense. See, one thing is mandated here, shall forward the daily diary report of all such cases fortnightly to the magistrate. Cases wherein session diary is maintained, and non-cognizable cases, that diary should also be sent to magistrate for examination. This was not there earlier. This is now mandated. Otherwise, the provision is same. There is no change in it. So this is there. Then, police officers' power to investigate cognizable cases. Considering the nature and the gravity of the offense, SP of police may also be, Superintendent of Police may require DSP to investigate the case. This is again a new thing. So we have to understand it in phases. One thing, how this information would reach DSP. Should it be sent to SP? SP will communicate it to DSP. How this is going to happen? This is not clarified yet. Law.
Send it through police manual, they make it clear. And insofar as deputing to the DYSP, they follow that manner. The moment the FIR, what is that notice, they delegate or designate a particular investigating officer. If you see the FIR, there's a detail sent to that. Under police manual, they already have it, insofar as Karnataka is concerned.
I'm talking about the entire state, this is entire country. This is one thing. Second, how this inquiry by SP needs to be done. That is not mentioned here. What nature of offenses? Considering the nature and the gravity of the offense, it is very subjective thing. So again, for this thing, rules are not made when this discretion should be exercised and what level of inquiry should be done, right? But this is permitted now. Again, see, the cognizance that was being taken under 190 earlier CRPC, that is now under 210 of BNSS, right? So now it is mentioning, after considering the application supported by an affidavit made under subsection 4 of 173, and after making such inquiry as it thinks necessary and submission made in this behalf by the police officer, order such investigation as above mentioned. When? In cases mentioned in subsection 4. And what are the cases mentioned in subsection 4? You see, any magistrate empowered under 210 may, upon receiving a complaint against a public servant arising in the course of discharge of his official duties, order investigation subject to. Now the public servants are given certain safeguards, right? Private complaints coming against public servant, magistrate shall not take any action unless this is there. What? Receiving a report containing facts and circumstances of the incident from the officer superior to him. So if any private complaint is made against a public servant before a magistrate, magistrate shall not proceed unless he gets the report from a superior officer of the public servant, concerned public servant, one. And second, after considering the assertions made by the public servant. That means two people should be heard. First, the public servant. What does he want to say to save himself from false allegations? And second, report of the officer who is superior to that public servant. These two things are required under this new provision. At the same time, we need to just understand a few more things. Any criminal justice system we have in the present time is either inquisitorial or adversarial, right? Inquisitorial systems are those systems wherein the judge actively involves in the inquiry. And adversarial systems are wherein there are two parties open to competition, prosecution and defense. Prosecution creates the adversary for the defendant, and the defense has to come out of that adversary, in simple terms, right? We are a mix. An addition of this kind of provision is again a shift from adversarial to inquisitorial, because judge has to conduct an inquiry in such cases, right? And that inquiry would relate to these two things and an affidavit, after considering the application supported by an affidavit made under subsection 4, after making such inquiry as he thinks necessary and submission made in this behalf by the police officer. Two stages, police, affidavit, right? Now, one thing that I feel here is the scope of inquiry is not mentioned, right? This inquiry which is being done is precognizance inquiry, then cognizance, then framing of charge. Again, some inquiries involved there, multiplicity of records, multiplicity of work, overburdening of judiciary. But at the same time, this safeguard was also necessary. So we have to, like I think for judicial wing, the state governments are not framing any rules. I think the High Court would be coming up with the rules which would be applicable to the judicial officers. What we are doing now is we are preparing rules for only the state machineries like police and prosecution, relating to investigation, arrest, lodging of FIR, summons, warrants, only these things. Judiciary we have left for the High Court, right?
This may include, may not be. So the discretionary power of the magistrate is given under state provision.
True, but the same thing applies as we were thinking about the police department, because police department also has checks and balance from the higher officials. Magistrates also have checks and balances from the higher judiciary. So it has to be clarified in further terms what actually is the ambit and domain of this inquiry, right? If let's say you take the decision to conduct inquiry, may if you proceed, then what would be the nature of inquiry? What would be the ambit of the inquiry? Then again, at the same time, I would like to draw your attention to one more thing. I started with the presumption of innocence, which is one of the most fundamental principle of criminal law, right? Just tell me one thing. Presumption of innocence says that no person shall be presumed to be guilty unless proven guilty. When you are conducting an inquiry at the pre-trial stage, there could be a possibility that you might come across some evidences which would relate to the culpability of the accused. You get my point? Because when you are conducting an inquiry, you would get the evidence. You would have to see the evidence. Without that, you can't conduct an inquiry. Just mere oral statements would not qualify an inquiry. If I am getting it right, and when you are coming across, let's say, knowingly or unknowingly, and then you proceed with the trial, would it not be a compromise in the cardinal principle of criminal law, that is presumption of innocence? Because you already had the opportunity to see the evidence against the accused person. Do you get the point that I am trying to make? No. He is not. What I am trying to say here is, you have got something concrete to suggest that he might have committed the offense, right? And this thing, see, Cardozo also says the judges are not devoid of these kinds of, we are human beings only, right? So when you have an opportunity to look at these evidences and you are conducting the trial, you know, see, I have seen that document. Is this not compromise in presumption of innocence? Yes, it might prejudice the minds of judges, right? So we have to now handle with this kind of situation also. I'm again reminded of one more thing, like a recent judgment, I think 2018. You remember that there was an amendment passed by this thing, under the POCSO Act, for any offense of sexual assault committed against a child of 12 years or below, death penalty was prescribed? Yes. Within 2 months, a judgment came from Rajasthan POCSO court, right? In that Rajasthan POCSO court judgment, death penalty was given. I think trial ran for around 1 week, not more than that. And the judgment started with an emotional poem. When a judgment starts with, see, death penalty provision says when you are giving death penalty to someone, you have to support it by reasons. Can emotions be the reason? Never. And when you are expressing emotions in words, see, we are humans. We cannot be robots. We have emotions, we are guided by that. There is no dispute in it. But at least that can't be expressed. And when you are expressing it, then I, as a law student, will pose the question, what? At what stage did the emotion arise? Did it arise at the time of the opening of the prosecution case? If yes, then you are not eligible to sit as an independent judge there, because your mind is prejudiced. Presumption of innocence is compromised. Now you are just waiting for some evidence to come and you want to convict. And if it arised, let's say it did not arise at the time of opening of prosecution. You were sitting like an independent judge. Trial completed. After that, sentencing. You would hear the party on sentencing also. Did it arise at the time of sentencing? If it arises at the time of sentencing, then this death penalty can't be imposed, because it might be guided by emotion. You get the point? So these things need to be understood, and we'll have to find a solution for this. Right? If this inquiry is being done by a magistrate, then should the same magistrate proceed with the trial? Or should the matter be transferred to some other magistrate? These things will need to be considered. There needs to be some concrete rules that the one who is conducting inquiry should not conduct trial. So it should be transferred to some other magistrate, like that. Okay. At the same time, one more thing worries me is, let's say, you conduct an inquiry at pre-cognizance stage, right? You would prepare some records. Those records will mention what? The findings of the inquiry, that there are some evidences existing against him. I heard him. He is saying this. Police is saying this. Officer is saying this. This report is there. When you send, see, what would be the conclusion of this inquiry? that cognizance may be taken, there is something concrete, right? Send it to other magistrate. What he will see? This person has come with this kind of noting, and that too from a magistrate. See, judicial officers are seen with lot of weightage. It is not just coming from a layman person or a person who is not holding a responsible position. Do you get my point? So again, at the same time, when the judge, other judge, it is transferred, he is looking at it. It is possible he might also get biased by just looking at the report that he receives. We need to find a solution for this. This I mentioned a few points, like overburdening of judicial work, ambit of inquiry is not mentioned in BNSS, it does not clarify. Then chances of duplicacy of proceedings at pre-trial stage, framing of charge, there also you are doing an inquiry, here also doing an inquiry, ambit is not clarified, we need to find a solution for this. Then 582 petitions, inherent power of the High Court. This is likely to shoot up. Inquiry is pending, this is happening if let's say magistrate has taken action. Inquiry finds that some cognizance needs to be taken. Now I will proceed to High Court for exercising the extraordinary powers to quash this kind of proceeding. You get the point? So again, there is a possibility that such petitions might shoot up. New provision of 582. It's 482. 482 typographical error. 528. Then 176, which was earlier 157, that is now 176. Procedure for investigation shall. This is only one provision line is added. May also be recorded through audio, video, electronic means, including mobile phones. This is again very crucial and important for us. I hope you are still with me. You are not tired? No, okay. Have you heard about the new app that is coming up? eSakshi? No. Okay. This eSakshi app is going to be a game changer if this is implemented. The NIC is developing this app. What it has is, see, everywhere it mentions about this thing, preferably by a mobile phone. Earlier it was not mentioned. Both the iOS and the Android users can install this app in their mobile phones. Now, what are the advantages? When you are conducting investigation and you are collecting evidence, the biggest challenge that any evidence faces is with respect to tampering, it's planting. Police did the same thing. It was not found the place of occurrence. Who planted? Like these things. Then tampering, then manipulations, these things are there, right? Then let's say some evidence is collected. Chain of custody. Who had the custody of it? Police officer, he collected it. He did not do anything. Someone else did it. How to find out? This problem is there. Then we have to collect it, produced it before the court in the best possible manner. But what happens? Many a times the collected evidence gets destroyed. So now, two things. What this eSakshi app would do, it is connected with the cloud server, right? It will have 3 stages. One, a recording of place of occurrence, right? A place of occurrence, how does it happen? You install the mobile phone, go to the place of occurrence, you click the button, place of occurrence, record. It has a capacity of 4-minute recording, right? And this 4-minute recording can be multiple files. So if in one recording you cannot do the entire recording thing, then you may add more files and then do a separate recording. Now, mobile phones which have inbuilt GPS system, they are compatible with this kind of application. What will happen? The moment you turn on the camera, it will record the GPS location, latitude, longitude, everything. Document, this evidence will be recorded, right? Then when you're conducting a search, then again, because see, in forensic investigation, as I told you in the beginning, in every case wherein punishment is 7 years and above, forensic investigation is mandatory, and at the same time, recording of the place of occurrence is also mandatory. That means you have to do it. So if this app is there, you do the place of occurrence recording. Second stage, when you are conducting search and seizure, their recording is mandatory, right? So again, you select that option, you record it. Now what will happen? After the recording is complete, if 4 minutes is not sufficient, you do add more files, again record. If not sufficient, add more files, like that you do. Then you press the sync button. The sync button will upload the file on the server, right? This application can be used by the judicial officers, that the evidence that is being collected, it will send to the judicial officer in real-time basis. The moment it is synced, a notification will pop up in your mobile phone that this case number, FIR number, accused people, place of occurrence, search seizure, forensic, everything is there. You can just click on that video and play it and watch it. Now, what are the advantages? Under section 65B, under 65B, you require certificate, Evidence Act, that is now section 63. Now, two formats are attached, you would be knowing this, part A and part B. Are you aware? Yes. Part A is to be given by whom? The occupant. The one who is commanding control over the device, right? So the one who is doing the recording thing, he can do it. He can give the certificate, part A certificate, or the SHO or the IO, whoever has the custody and command, he can give the certificate. Part B certificate is problematic. It is to be given by an expert. Who is that expert? You have to look for the expert, find out the expert. So this NIC app is being developed. At the back end, they have a team of experts. You upload it, automatically a certificate will be generated, 65B. That is now section 63. Part B certificate will be generated, so now it is easier for the police also, for the judiciary also. Objections relating to tampering would not be there. The one who is recording the place of occurrence also has to record with the front camera his own image, right? That he is the one who is doing the recording. Record it, put your own picture, photograph everything, details would be there, so you would be knowing who did the recording, when it is done, latitude, longitude, GPS location is also there, real-time basis it is being uploaded, and the best thing, it will generate the hash value at the same time. And when you refer to the judgment coming from the Madras High Court, Yuvraj versus State of Tamil Nadu, what is there? The court is suggesting that hash value should be recorded at 4 stages. One at the time of collecting the electronic evidence. So you do the recording, you sync it, hash value generated. Second stage, when the document or the record is being sent to the expert. Second stage, when it is being produced before the court. Third stage, when it is being sent to the expert. And fourth stage, when he is filing the report. All 4 hash values should match. If they are matching, there is no tampering. And this is the best solution. At the real-time basis, you are recording the hash value, and when you check it throughout, it will have to remain the same. If there is a change, that means there is a tampering. So the best possible solution. So that is why may also be recorded through an audio-video electronic means, but it is may here. It is not mandatory. It is suggestive. But it is possible that the state governments might, once this app is functional, then it might be mandated for every small thing, and it will also be better for the police official to do it. It will save them also from the defense lawyers, right? Am I clear till now? Okay. This provision is same, there is no change, fortnightly requirement, this you all know, I am not referring to this. But again, now subsection 3. On receipt of every information relating to commission of an offence which is made punishable for 7 years or more, as I referred to, forensic investigation is mandatory in every offence for which punishment is 7 years or more. This is one thing. 5 years time, within a period of 5 years by the state government, cause the forensic expert to visit the crime scene to collect the forensic evidence in the offence and also collect videography, cause videography of the process on the mobile phone. Mandatory, both the things are mandatory. 5 years time is needed, and it is also saying wherein, let's say there are border areas which are not well equipped, so help from neighboring states may also be sought, right? And second thing, you also would be knowing that mobile forensic labs are being developed now. These mobile labs in a van, like an ambulance, well equipped, they can go to places, collect evidence. They have incubator, then they can sterilize, because many evidences are destroyed when they are in transit. A lot of fungus might develop in wet objects like that. So these incubators will sterilize it, dry it, seal it, collect and send it to the main laboratory. So in this manner, this forensic mobile labs can be of very help, right? See, this is mentioning, provided where forensic facility is not available, and see, from other states it may be borrowed. At the same time, when the law is suggesting about forensic investigation, police department also needs to be well aware, and you as judges would also understand. See, those who, if you have the opportunity of reading forensic science as a subject, you would have seen that there are different mechanisms through which evidence is collected, through which search is made, like the spiral method, quad method, wheel method is there. So when you do the search properly, because what happens when the time of conducting search, many times police officer steps on the physical evidence, and that physical evidence gets destroyed there itself. How to collect it then? It's of no use now, right? So when you do these things systematically, are you aware of these methods? Cycle method, quad method. Okay, just to give a brief introduction about this. See, any place of occurrence needs to be secured and marked. Let's say this is the hall, is the place of occurrence, let's say. You do a, let's say, a spiral method. A spiral method is like the chakra view. Chakra view, you understand? So from the center, you do the marking like this, spiral way. You conduct an entire search of the hall. In what will it help? How will it help? It will allow you to know what area you have searched, so that you need not search the same place again and again and waste time. 1. 2, when you do this kind of marking and do the search, it is possible that you are walking and just looking at this stage like this, so that you are not stepping on any physical evidence which might be lying there unknowingly, because you are following a unidirectional approach. This is one way. The other method is, you may divide this area in a chord, 4 sectional, straight line and a straight line. So now there are 4 options, 4 places or 4 parts of this entire place of occurrence. In each place of occurrence, you have the liberty of following any mechanism. In this, let's say this chord, I may follow the spiral method. I may follow a strip method. Strip method is, I do not have pen and a marker. So it's like how a snake walks, like this. You understand? So this is what? Zigzag. String method. You are walking like this. First you walk like this, you search this area, and then you take a U-turn, you walk like this, and then you conduct the search. So again you are following a pattern, so you know that this area you have searched, this area is remaining, and you would not step on any kind of, physical evidence that might be lying there. Then wheel method. You all know how a wheel looks like, a cycle wheel. It has spokes, right? So this entire room is the place of occurrence. You form a circle, and then you go to the border and then come back. there, and then like spokes, a wheel would be formed. So again, you are doing a detailed search. See, you are just not moving randomly, you are doing this kind of search in this area and that area is remaining. So this way you are conducting a detailed search of the entire place of occurrence. So if this is followed, there are better chances of collecting physical evidence from the place of occurrence. Right? This is one thing. Second, so now when the CRPC or the BNSS is being permitting or mentioning about forensic investigation, it is for all the stakeholders to know and learn what mechanisms may be adopted. Like one more example I would just like to give to you all. Simple thing, like have you heard about the scientist Edmund Locard? Anyone? No. Okay. Edmund Locard is a scientist, was a scientist, like he's dead. He gave the principle of exchange. Principle of exchange, that is best way to explain how physical evidences, how latent impressions may be collected or physical evidences may be collected from place of occurrence. Simple example. We all are sitting here right now, right? If let's say, if I tie a cloth, cover your eyes, all of you, right? And then you are brought to this room to sit here. Would you think that there may be hundreds of people and there may be just 5, right? So therein, oral testimonies or oral evidences fail. Why? 1, perception. What you saw, what you perceived, there might be a gap. And what you testify in the court of law, there might again be a gap. And then what you testified, what judge understood, again there is a gap. This is one. And this gap is possible when all the people in the chain, they are acting with utmost honesty. Witness is saying, I am honest witness, I'll tell only the truth and nothing but the truth. Judge is also actively sitting, engaging, observing the demeanor of the witness and noting down everything. Then again these gaps are possible. Let's say the witness is lying. If the witness is lying, everything is lost. How will the prosecution proceed? Even if, let's say, conviction could be established in appellate court. You get the point? So therein, forensic investigation helps. 1, this is scientific. Scientific. You are covering major area. And then when you're taking photographs, maybe there are stages. The manner in which you take photographs, closer photographs, mid-range photographs, and wide-angle photographs. Our mobile also has this kind of thing. You zoom in, mid-range, and then the entire view. So that ways you would be able to find out that at what place actually the witness or the evidence was lying. Right? I was talking about Edmund Locard and then I deviated. Edmund Locard is talking about the principle of exchange. If your eyes are closed, you won't be able to see or testify before the court of law. But it is possible that your presence in this hall can be confirmed by other mechanisms. If you are allowed to testify orally, you can only see and then observe. Or the 5 senses that we mentioned, oral evidence, must be direct, seen, touch, taste, smell, and hear. Besides these things, we humans might fail. And there are few things we can't even see. If we can't see, we can't touch and understand. So likewise, fingerprint. Fingerprint, you all understand? Best method of identification. We can involve here. Fingerprints, how they are formed? Locard simply says, I'll just take 2-3 minutes. All of us, we can see that the skin on this palm is different from the skin on the rest of the body. And the same too applies to foot also. The skin is different, right? Why is it different? It is scientifically. This kind of skin does not release oil. Other skin becomes oily, face becomes oily. If we have oil on the skin On the palmar surface, this is called the palmar surface, and this is dorsal surface. Palmar surface, if there is oil, if you try to hold some glass, it will slip off. The skin is designed differently, 1. 2, if you all can see in day's sunlight, you can see that there are some ridges. The skin is rough. Why is the skin rough? They are ridges formed on the skin. It is the characteristic of the skin. There are elevations and there are valleys. These elevations are called friction ridges. This helps people to touch and understand, to hold things. It has more senses, sensory organs as compared to other body parts. Now, when any person, you are sitting here, you are holding pen in your hand, you will leave a trace behind. Because Lukart says, when two physical things come in contact with each other, they leave their trace behind. Simple. When two physical things come in contact with each other, they leave their evidence behind. So even if I close your eyes, if I do not allow you to smell, you won't be able to find out you are sitting with whom. Forensic science will help. Right? So when two things come in contact, they leave their traces behind. So you are sitting here, you would leave a trace behind. If we involve scientific investigation, we can simply easily collect fingerprints, because you would have sat on this chair, you would have kept your hand on the armrest, or the book, or the notebook, or the pen, whatever it is. You get the point. These friction ridges are unique. No two person in this entire world can have same or similar friction ridge. This is one thing. Second, even twins can't have similar finger impressions. It is scientifically proven. Third thing, we might think that no, science has developed so much. Through surgery it can be created. It is scientifically proven that we cannot create extra friction ridges with the help of surgery also. And that is why, see, NCRB is collecting data of, we have Criminal Procedure Identification Act 2022. Right? These data are being collected. So if you have a repository, you can simply cross-check. Right? Scientifically, it is established that doctors have tried to create extra ridges or remove ridges. It is not possible. And the fourth thing, even whatever friction ridges that are there on your palm at the time of birth, it will remain the same throughout your life. It will never change. Never. Either by surgery or by some kind of, like people might face some kind of skin infection like that. So they may change temporarily, but it will not change permanently. So if these things are involved, right, and there have been cases, like even Supreme Court cases are there, wherein let's say simple thing, criminal investigation is happening, at the place of occurrence, police found the gun. What is the most common sense thing that the police should do? Seize it. How? Not bare hands, with the help of gloves, and send it for forensic investigation. Two things, see how, that's why, see, it is said, no, witnesses may lie, but circumstances don't lie, right? You collect this gun, send it to forensic, it will have finger impressions, probably yes. It can be matched with that of the suspect. Gun can be test fired, the test fired gun can be again compared with the bullet that was recovered from the body of the deceased. Again, chain is complete. It will help in conviction, right? So again, see, with respect to these things, again some questions might crop up, as if the offender is using gloves, he might not leave any trace behind. This is not possible. Human body is shedding dead skins every second, every minute. So if you collect the dust particles from the place of occurrence, that can be studied to compare with that of the suspect, one thing. Second, there are evidences to suggest that even if the police, this accused criminal, they are not using gloves. Reason being, when you are going to commit crime in a dark place, you can't see, right? you only use your hands to touch and identify things. If you're wearing gloves, you won't be able to do that because your senses won't be working properly. So they have to remove gloves and then touch and identify things, right? And then again a question might arise, when there is no secretion of oil from the palmar surface, then how would the impression be created? You get the point? There is no oil on the skin, how would the impression be created? It will be created. How? See, we all have this habit, if I just observe you, some is sitting with, like you would definitely touch your hair, head, your face, or other portion of the skin, right? When we are unknowingly touching it, the oil gets placed on the palmar surface. When you're touching different places in the place of occurrence in the dark, unknowingly you would attract some dust, some other particle, which would be placed on the palmar surface. Wherever you touch, you will leave a trace behind, and the Locard principle stands perfect in this place. Forensic investigation can easily aid in investigation. Am I able to clarify it? Okay, I'll move further. Report how submitted, this is there, the law is not changed, the same provision is there. Shall be submitted without delay to the magistrate. 159 is now 178, is again same, there is no change in it. Magistrate on receiving a report under 176 may direct an investigation. The same thing 156, which was read with 159 was there, the same thing is here. Again, this is also same, the law is not changed. Examination of witness by police, examine orally or any person. Simple thing, the same is there. It is not, one thing, I'll come to this. Statements to police and use thereof. Okay. When the police is recording statements, again, the same procedure applies. They may also do video recording. They are suggested to do it. What will happen? That will save witnesses from turning hostile. Now what police are saying, police personnel, what they actually do? They listen to the version, go to the police station. After 2-3 days again, they might think today I can record it. They might not record it on the same day. Or they may just note down a few words. I have to develop my story. They'll record it. So they are little redundant, like apprehensive, what will happen. But we can enforce it. If you are recording the statement of any witness or any victim, record it in mobile phone. Best way. It will save you. Because see, defense is going to take the advantage. This statement is extracted one. This is a forged one. You tortured him. You threatened him. You coerced him. Like that. So best is do the recording. Right? So the regulations, the rules that the governments are framing, they might mention specifically that it is preferred that you do the recording in such kind of situations also. Statements to police and use thereof, you all know that statements recorded by police, confession recorded by police, they can't be proved in a court of law, right? What is the evidentiary value of such statements? Anyone? How much weightage do you give to such statements recorded by police? That's it. Simple terms, police has the opportunity, occasion to create things, to coerce things, to manipulate things. And for the same reason, the law was there and it still stands the same. The statements recorded by police, they are not, in our jurisdiction, like we have separated police from prosecution and trial. So the same thing here applies again. It can be used for contradiction and all. So earlier section 32 was there for dying declaration. Dying declaration is an exception. It is now section 26. One thing I just would like to add here, is there a format prescribed for recording dying declaration? Yes? No? It is there? What is the format? For? Huh. Okay. Okay, prescribed by state government, Karnataka. Okay, that's good. And who has to record it? Tehsildar. Executive magistrate. Okay, okay, okay. Just to clarify a few things around this recording of dying declaration. There is a form prescribed to be recorded by executive magistrate, but is it every time possible that the person who is about to die would call up the executive magistrate to please come over, I want to give my dying declaration? It is also possible that the victim might not reach the hospital. Yes. Yes. With respect to dying declarations, every person, including magistrates, judges, executive magistrates, police officers, private persons, anyone can record. This is one thing. Second thing, if you refer to the series of judgments that have come from the Supreme Court, right, we can decipher a few fundamental principles that we need to follow. One, the objections might crop up before the court is, whatever declaration was given by the declarant, was he in fit mental state to give the declaration? Because as per Evidence Act, any person who is able of understanding questions and answer them logically is a competent witness. But how do we understand whether he was able to understand the questions or not? If he was not able to understand the questions, he can't be a competent witness. And if he can't be a competent witness, you are relying upon his testimony and trying to convict this person. You get the point? At the same time, so if you have to draw some weightage, put some weightage on the declarant statement, then you should have safeguards also. But that safeguards can't be complied in every situation. On the way to the hospital, the victim dies. Like situations might arise. So, preferably, dying declarations should be recorded in question answer format. You mention the question also, post the declarant, then record the answer given by him. Now the question when reviewed by the court will have the opportunity to know that he was able to understand the question and then he answered it logically. You get the point? This is one thing. Second thing, there has to be a connection between the question and the answer. This can also be seen. But this declaration recorded, it can't mention specifically whether there was any kind of tutoring or not. You understand tutoring? Was he prompted to speak like this or not? How do you find out? How do you find out whether the one who recorded the declaration read it over to the declarant and then he certified, yes, you are right, you have recorded in correct manner? This is also not possible, right? So now video recording is the solution. Video recording is the best solution possible in such cases. Though we understand that, see, there are various checks and balances which we need to see. So if police is recording a dying declaration, again, he can do so. But at the same time, checks need to be placed, right? Whether the person was in fit mental state or not, certificate is in such case is not required because there was no doctor to examine him. Ambulance guy is taking the person to the hospital, he can also record it. He can give the certificate, no, he can't give the certificate. Like that is there. He came across a police officer recorded it. That's allowed. But can conviction be established on the sole evidence of a dying declaration? Yes. Yes. If it inspires the confidence of the court, yes, conviction can be established. There is no harm in it. But now in this age of technology, in the light of the new provisions, you can also suggest when you come across such kind of cases to record it in mobile phone. That's the best possible solution, right? Then no inducement to be offered. You all understand this. At the stage of police also, at the stage of recording of confession by magistrate or statement by magistrate. A few things again I need to highlight. The new criminal law has removed the nomenclature judicial magistrate. It has removed the nomenclature metropolitan magistrate. It has removed the nomenclature or the position of assistant sessions judge. So everywhere you will find any magistrate of the district. If it is executive magistrate, then it is clarified, executive magistrate. Otherwise, everywhere magistrate is used, that magistrate implies judicial magistrate in simple terms, right? Now, which was there earlier in 164, recording of confession and statements by magistrate, that is in now 183. The law stands the same, there is no change except a few things like relating to offense against women. Statement shall be recorded by a woman magistrate. If woman magistrate is not available, then in the presence of any women officer. This is one thing. Second, in every case, one thing is again mandated. In every case where the offense relates to an offense is punishable with 10 years or above imprisonment, punishment, it is mandatory for the magistrate to record the statement. It is not optional then. In every case wherein the punishment for the offense is 10 years or above and the witness or person is brought before the court for recording the statement, it is mandatory to record the statement. It is not optional in such cases, right? This is second. Do we have to wind up? Okay. We'll meet after the break. I know. Thank you.
Good afternoon all. Welcome back to the post-lunch lesson. I request sir to continue his lecture on the provisions and reforms related to proclaimed offenders, trial in absentia, evidence of public servants, experts, and also pre-trial process and role of magistrate and prosecutor from FIR to filing police report, from taking cognizance to commencement of trial. Thank you, sir. Over to you.
Thank you. So we were discussing about section 183. We started with this only. 183 is same as 164. It was existing under the old CRPC. A few changes have been introduced in this. One I referred as wherein the offense of a sexual nature is committed against a woman, then it shall be recorded by a woman magistrate as far as practicable, and you will see this thing, the yellow highlighted one. And if it is not possible, then by a male magistrate in the presence of a women officer. First line, right? Second thing, provided that if the offense relating to offenses punishable with imprisonment for 10 years or above, the magistrate shall record the statement of witness brought before him by the police officer. So in every case wherein the offense is punishable with 10 years or above punishment, then the statement shall be recorded. This is mandated now, right? The same shall be recorded also videographed using a audio video electronic means, preferably by a mobile phone. At this stage, like I would also wish to draw your attention to certain points relating to recording of confession and recording of statements. One thing is very clear, the previous section was also there, that inducement, threat, promise shall not be offered to the confessor. If a confession is being recorded by a magistrate, then it shall be avoided. So going to the background, confession can't be, police can record the confession, but that can't be proved in the court of law. This is point number one. Confession recorded by judicial magistrates, they are called as judicial confessions. Recorded by police, they are extrajudicial confessions. Judicial confessions have some extraordinary weightage value attached to it. And for the same reason, certain safeguards, certain protocol needs to be ensured, needs to be followed. One thing, that who would bring that person before you? A police officer. A police officer is not allowed to record a confession and prove it in the court of law for obvious reasons, right? So if person is coming from his custody, then there are possibilities that there may be some application of inducement, threat, promise, torture, coercion, etc. Law is presuming it to be true, and that is why law is not allowing them or confessions recorded by them to be proved in the court of law. So as magistrates, our responsibility is to ensure that the confession is voluntarily made. Because you all understand that we have Indian Constitution. Indian Constitution says what? That a person cannot be compelled to be a witness against himself. Simple. He can't be compelled. A person accused of an offense cannot be compelled to be a witness against himself. So there are a lot of judgments you would have read about the term who is an accused person. When does a person become an accused person? Can you please tell me? Anyone? When can we say that a person is an accused person? With the lodging of FIR? After that? When he informed of the charges, of the grounds of his arrest. Arrest or charges, framing of charges? Arrest, right. That means it is coming after after filing of FIR, presumably, right? So if we say that a person becomes an accused person only with the arrest or when he is informed of the grounds of arrest, then that means the protection of Article 20 Clause 3, that is, no person accused of an offense can be forced to be a witness against himself, will apply only after he is informed of the grounds of arrest. Did you get my point? This means that a person, unless he is arrested, would not be protected by Article 20 Clause 3 because he is not an accused person. If he is not an accused person, his safeguards under 20 Clause 3 does not apply to him. What does it mean? It means that a person can be forced, beaten, tortured, caused. ठीक है? I take your point also. That means if I disagree with sir and go beyond that, sir is saying with the arrest and information of the grounds of arrest. So till that time he can be, let's say we'll go beyond that. With the lodging of the FIR, a person becomes an accused person. That means police can delay the lodging of an FIR and coerce him, torture him, beat him, threaten him, and compel him to make a statement because he is not an accused person. Did you get my point? Because 20 Clause 3, what it says that a person accused of an offense cannot be compelled to be a witness against himself. And the entire idea behind compelling someone is to give a testimony against whom? Against himself. Self-incrimination is not allowed. This is what Indian Constitution conveys, right? Then what is the purpose of this 20 Clause 3? If we are calling only such people against whom an FIR is lodged or a formal complaint is made as an accused. What about 183 safeguard? Police can catch hold of someone, put him in lockup for a number of days. Arrest memo is not required. Okay. That will amount to illegal confinement only when the case reaches before the court. Okay. You have given a very good, direction to this kind of discussion. If we go by the provision, a new provision is added. Huh.
97 section.
True. A new
File
provision.
the application before the magistrate to issue the search warrant.
Fine, I got your point. Just to add on, sir, your question is right, but the question is will come at the later stage. I am talking about something at the prior hand situation. You added one more dimension. Sir is saying that you cannot arrest. If you arrest someone, you keep in police lockup. You keep in police lockup, and then writ petition would be filed, and that person needs to be produced.
We can file the application before the magistrate.
Right,
under
right.
Section 97 of CRPC.
True, true, absolutely. Law is also saying the same thing.
We can take the search warrant.
Law is also saying the same thing, sir.
Along with commissioner, you may be the advocate.
Yes.
To the police station and search whether there is any person illegally confined.
Absolutely.
And if any person is illegally confined, then you should be taken before the magistrate.
Okay. Now I just me add few points to this. The law has been now added with one more provision. It says, and you would be surprised to know this. It says, when a person is under confinement, like in police custody, he would be in a jail or a police lockup. Sorry, he would be in a police lockup. When a person is in judicial custody, he would be in jail. Law is not assuming any other place to be a place wherein a person would be confined. In a way, law is unable or not trying to address this kind of situation wherein I, being a police officer, catch hold of someone, put it in my house. Law is saying if a person is in police custody, he would be in police lockup. Other than that, it is not talking about. Transit remand is issued. Person who is in police custody or police remand, they travel for several days also in their vans or in their whatever kind of facility they have, one thing. Second, there are houses which are wherein people might unlawfully, I'm not talking about lawful confinement, I'm talking about unlawful confinement. Do you get the point? So if I go by this definition that a person is an accused person only when an FIR is lodged, and again purpose of 183 and purpose of 20 clause 3 would be defeated. That means it is not protecting such people. No. Okay. Sir, I request you, all of you, to please go through the judgment of Supreme Court, Nandini Satpathy versus P.L. Dhani. The Supreme Court judgment very well clarifies that for the purpose of, see, Article 20 Clause 3 cannot be interpreted narrowly and it cannot be interpreted in isolation. Right? It is to be read in the light of Article 21 also, one thing. What Supreme Court judgment is saying, if we give this kind of narrow interpretation to the term accused, as referred by you and as referred by you, we would be segregating a large chunk of people against whom a formal complaint is never lodged, who are never arrested lawfully. We all know these things that happen, and who are confined unlawfully. These unlawful practices may be done against them, and after that an FIR may be lodged to give it a lawful shape, a legal shape. So court is saying we include all such people who are potentially accused, not accused, potentially accused. That means who might face criminal prosecution in any time in near future. Then only purpose of 20 clause 3 can be served, otherwise it would fail. So now, if we are giving wider interpretation, considering this judgment of the Supreme Court, then what is happening? Every person whom police is thinking of prosecuting, police is thinking of arresting, police is thinking of making an accused, all that is covered within the ambit of the term accused in 20 clause 3. So this protection applies. And herein comes the role of a judicial officer, person, when he was arrested, when he was brought before the court of law, how much time he was in the police custody, how much time did the police take between arrest and traveling to the magistrate's court or to the police station like that. Then at the same time, am I audible? Then at the same time, you have certain safeguards, mandates coming from Supreme Court only through various decisions, like as well as read with Article 183. Through interaction, you have to find out that the person was not subjected to any kind of inducement, threat, promise, coercion, torture, etc. Second, if you have an apprehension that there might be some application of inducement, threat, promise, coercion, torture, etc., you have to give a cooling off period, right? That cooling off period may go up to 24 hours, 48 hours, 72 hours, depending on the satisfaction of the magistrate who is going to record the confession. This needs to be followed, right? At the same time, you, before recording the confession, have to warn that person that you are not bound to confess. If you are giving confession, what would be the implications of giving a confession? Because it would be used as an evidence against you. And this also has some extra weightage as compared to an extrajudicial confession. This is not some layman who is recording a confession. This is not a private person who is recording a confession. You are making a confession before a judicial body. And it will have implications upon your right, your liberty, and upon your life. Do you get the point? So you have to give a warning. And for the same reason, there is a declaration attached. You would have seen that. And you would be doing that also. If person is coming from a police custody, these apprehensions become stronger. If a person is not in police custody, then there is a possibility that these apprehensions are little reduced. Am I clear to all of you? Right. So same thing is mentioned here in attempts have been made, same thing, that wherein offence is committed against women, law has been made more elaborate, more clear, that it should be done by a women magistrate. Right. This is the declaration, you have already seen this. Okay. Medical examination of victim of rape, next section 184. It is same, there is no change in it. In the first subsection, other sections there are some change. This is about the examination. One thing is there, within 24 hours from the receiving of the information, police has to get the medical examination done of the victim, right? There have been cases wherein the informant told the victim told the police that offence occurred on such and such date. Police might think that no, so many days have passed, already passed. So some essential evidences would have already flushed away. So there is no point of taking the victim to the doctor. No. You receive the information, you take the victim to the doctor, medical expert, for the purpose of examination. This is mandatory, one thing. Second, consent of the victim or someone who is competent to give consent on the behalf of victim shall be taken. There are series of judgments from the Supreme Court that an examination which is done without the consent shall not stand the legality, right? So consent should be recorded in writing. So for the same reason, we go to doctors give that consent form, you write and you mention that you subject yourself like that. If you're denying, you also mention that, right? Then consent, see this last line, subsection 4. Consent of the woman or the person competent to give consent shall be recorded. Now, there is one deadline, timeline attached. So you would see that across BNSS, at several places, timelines have been fixed. So medical expert who is conducting the examination shall submit the medical report within 7 days. See, within 7 days, forward the report to the IO, who shall forward it to the magistrate under section 193 as part of the documents. So this is now mentioned specifically. Then next, section 185, which talks about the search by police. One change is brought here. If you see this case diary, it is mentioned. If you have the older Bear Act, the earlier one, CRPC, it mentioned about the station diary, right? This provision is falling within the chapter investigation, which is happening only after the lodging of an FIR. When FIR is lodged, there would be a case diary, so you make a mention in the case diary, which is why this term station diary was removed with case diary specifically. Second thing, it is mandated that in every case wherein search is being done, there should be a video recording. So I was referring to eSakshi app. You take the mobile phone, install with eSakshi, simply press on the appropriate button, record it, and sync it. Once it is synced, it is saved. Then in real time basis, you can download the certificate also, right? So preferably by mobile phone. Provided that search conducted under this section shall be recorded through audio, video, electronic means, preferably by mobile phone. Which mobile phone? Whose mobile phone? Police might say, see, when I have been interacting with police, they feel that our mobile phone will be seized. If I do the recording in my mobile phone, court will seize my mobile phone. So I will not record it in my mobile phone. So they may think of other options, like if they have recovered some mobile phone which was stolen, they might use it. Senior police official might ask the subordinate to give his mobile phone. This is possible. They might take the mobile phone of the premises, the person who is living in the premise, and do the recording in that mobile phone and ask them to send a copy of the same. This is also possible. For the same reason, eSakshi app is coming. These possibilities, these apprehensions are there, and they were reluctant. They were not believing that they have to use their own mobile phone. And what about storage? My mobile phone is already filled. I can take the plea before the court of law. I had the mobile phone, but memory storage was full. So how do I do that? Right. So these kind of things, isliye there is a cloud memory provided by NIC. You upload it. Your mobile is safe, right? Now, one more timeline is added. When search seizure is conducted and some record is prepared, that record is to be forwarded before the magistrate within 48 hours before the nearest magistrate, wherever search is being conducted. So, right? So this timeline is again added, not later than 48 hours. This 186, as it was in 166, provision is same. There is no change in this section. This is there again. Here it was judicial magistrate. Now it is magistrate because the nomenclature is changed. Now there is one more change in this police remand thing. 169 was also talking about several things like default bail, right? So some changes are brought herein. Like initially, person who is being arrested, right, would be in police remand for a maximum period of how many days? 14 days? 24 hours had already passed. No. So total 15 days, 24 hours plus 14 days, right? But there is a possibility that while after this, on this duration is counted from the first date. From the date of arrest, it is counted, right? So since the date of production, because that's the timeline we can fix, right? From there, 14 days, right? But there is a possibility that the person, the IO, might receive some evidence after the expiry of this date. So law is now changed. And you all know, though the criminal law does not prescribe within how much time generally an investigation should complete, but it is suggestive in the sense that for any offense for which punishment is 10 years or above, investigation time is 90 days. And for any offense for which punishment is less than 10 years, it is 60 days. And on the expiry of this date, the person, if he is in custody, gets a right to default bail, right? Now, in all cases, within 60 days investigation time is provided, in first 40 days, this remand of 15 days may be taken, 14 days may be taken. In first 40 days, this remand may be taken. And for all offences for which 90 days investigation time is provided, first 60 days, 15 days remand may be taken. This is a new development, and this will help prosecution and police in some way or the other. Am I clear? In 60 days investigation time, 40 days timeline is there. In first 40 days, you may take it as a whole or in gaps, right? Likewise, in 90 days, first 60 days, you may take the remand, right? So this is one development. What I was referring to earlier, this proviso has been added. Provided further that no person shall be detained otherwise than in police station under police custody or in prison under judicial custody or a place declared as prison by the central government or the state government. What I was referring to, that the provision which is added does not mention about transit remand. 1. 2. Under 27 of the Evidence Act, you would be knowing that discovery statements are made. Police takes that person to the place of occurrence or where the evidence is hidden. So where to keep that person at that time? So you are taking that person out of police lockup at that point of time. When law was mentioning about these things, specifically, they could have also added one more provision about the same thing or acknowledging the same thing, right? But it is silent on this point, so we are assuming that they are only saying that person should be detained either in police lockup or in jail. Same thing is there. I just highlighted because judicial magistrate was replaced with magistrate. One mistake committed, clerical error only. They forgot to erase judicial magistrate from one place. Everywhere they have erased. If you go through the entire BNSS, they have forgotten to delete it. They might delete it with an amendment. Okay. These provisions are same. Just section numbers have been changed. That's it. One thing is clarified in the proviso, that cases to be sent to magistrate when evidence is sufficient, right? So person, provided that the accused not in custody, the police officer shall take security from such person for his appearance before the magistrate, and the magistrate to whom such report is forwarded shall not refuse to accept the same on the ground that the accused is not in custody. In simple terms, it is clarified that person, if he is out of custody, magistrate shall not reject the case just because he is out of custody. That's it. Just a clarification. No fundamental change. See, 192 has a renumbering of the subsections. 1, 2 have highlighted the subsections 2 and 3, 4 and 5 like this. Otherwise, the provision is same. 193 has some change. 193 is same as 173, filing of a police report. For offences relating to sexual assault in POCSO and for offences relating to rape, investigation is mandated and it shall complete within 2 months from the date on which the information was recorded by the officer in charge of police station. Right? This is one thing. Second, one fundamental change that has come in 193 is filing of the police report electronically. You get the point? That now police is not only supposed to file the hard copy of the police report, but a soft copy as well. Says including. As soon as the investigation is completed, the officer in charge of police station shall forward including through electronic communication to a magistrate empowered to take cognizance. Now, again comes in the role of e-Sakshi. You do everything online in the mobile application, enter all details, submit to magistrate, and magistrate will be able to see in the mobile phone itself or tablet, whatever it is, that what case is. And see, at several places you have seen already that police is doing the video recording. That needs to be filed before the court, right? So here is the solution. And when this report, and see also, 190 CRPC earlier, cognizance by magistrate. Three ways: suo motu, police report, complaint. Now, police report, along with police report, it is also mentioned electronic means, communication through electronic means. So that means a magistrate can take cognizance not only on the basis of the hard copy, but also on the soft copy, and maybe with time the hard copy thing is done away with. Everything would be digitalized. There could be a possibility. But firstly, we have to test run this e-Sakshi application, which is connected to CCTNS 2.0 like that. One more thing. Investigation is being done. Investigation is being done, right? In investigation, now we discussed already, there are possibilities of getting electronic records also from the place of occurrence, right? Wherein, let's say CCTV footage is there. That is what? An electronic record. Electronic record being seized by the police. Record is being seized by the police, there are chances of its tampering after the seizure took place. Maybe it was deposited in the Malkhana that we call it, I do not know what is the name of that place here. Property room, right. That is deposited there, someone gets the access and tampers it. So these things are possible. So either way, what is saying, you have to specifically mention the chain of sequence of custody in case of electronic evidence. And there is a format prescribed also for this. Format is mentioning three details particularly. One, it would be relating to the case. Case details, which would mention sequence number, FIR number, details of the case, name of the IO, done on which date, like lodged on which date, then signature. Second is that of the details of the device, right? In details of the device, it would mention the name of device, its make, its model, type. Every device mostly has a serial number attached to it, right? The serial number of the device, you mention it, and then collected by whom, seized by whom, right? You mention that and sign. And third form is about the sequence of custody, mentioning this particular officer seized it on this particular date, at this particular time, signature. If this custody is being transferred to someone else, the recipient would mention received from, given to whom, date, time, signature. So like that, this will have a compilation, exhaustive details of the case details, device details, as well as sequence of custody. And this format needs to be attached with the police report mandatorily. You will also get a copy of the same format, right? This format is mandatory, it should be attached. Earlier, this was happening only with respect to the forensic samples which were being collected, right? Now, this is also for this thing, whatever electronic record is being seized from the place of occurrence. Now, this is again a good thing. I, being informant, go to police, lodge the FIR, I do not know what is happening to my case. I go to police, police tells, I'll inform you, update you later. And for this, there have been series of judgments also wherein courts have said that police should inform, give an update to the informant. Now, the same thing is getting statutory recognition, that police shall, within 90 days, from the date of the lodging of the FIR or the receiving of the information, should give in a status report to whom? The informant or the victim. Where victim is the informant, not a problem. But this is mandatory. Provision is not mentioning for how many times this information to be given. Just once, twice, thrice, how many times? This is not mentioning, but the rules would prescribe that it should be regularly given to the informant. Because see, the point here is, if the informant is not satisfied, he might approach the court. So he needs to be convinced so that there is no duplicacy or multiplicity of proceedings. So that needs to be answered. So which is why this provision is there. Now this communication through electronic means is also possible and is considered sufficient compliance. Every communication. So given this thing, giving the information to the informant through electronic means. Means is not clarified. Which method of communication? WhatsApp, email, phone call, text message, what? Not prescribed. But again, some method should be there and it should be documented. If it is not documented, again questions will arise that you did not give the information to the informant. It needs to be documented, one thing. Summons. Yes, yes. That is there. Provisions relating to summon is now amended. E-delivery of summons is now allowed. Yes, 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 yes. That is enough. And see, when, okay, just to clarify one more thing, since you have started this discussion, best option that might, I believe, would be the future reality. We all know people might not have installed WhatsApp in their mobile phone, but text message is inherent in every device, right? Summon may be uploaded on the website of the respective court. Link of the same shall be sent to the personal mobile phone, mentioning that this is a summon. Click on the link, it will open automatically. The contents of the same may also be mentioned in the text message itself. That is sufficient delivery. That's what I am saying. WhatsApp everybody might not have. So mobile phone number you may call, text message may be sent, email ID is there, you may send it on the email ID, right? And the other traditional method is already there, that is existing. So both may be combined depending on how feasible it is for the courts and for the officers who are executing it, right?
Sir, 164 earlier,
Just clarify
CRPC
your-
earlier,
okay.
earlier ones, 164. Any magistrate of the district, it may be include executive magistrate or who may be taken as a confession statement. Executive magistrate also take confession.
Okay. Here it says any magistrate. Any magistrate refers to judicial magistrate. Because for executive magistrate, the law is very clear. They are specifically mentioning executive magistrate. One thing. Point number 2. Reason why any magistrate is mentioned, because see, again thing, principle, presumption of innocence. I am the one who has to conduct the trial. I also record the confession. Then I conduct the trial. Purpose would be defeated.
Another one.
Yes. So,
The new
one second, just to clarify. So, in the district, yes. True. Yes, yes, true. That's the same thing. Even if the police wrongfully takes it to the magistrate having jurisdiction to try, they should refer the case to the other magistrate and should not record the confession themselves.
Sir, 3 days of accused, if come to station and he signed to police station, if he abscond anywhere, कहाँ तो गया तो अब उसे कैसे station में लाके पकड़ना वो कैसे?
Okay. So 3 days time is required for signing of the information.
Yes, sir. Yes,
Yeah, that's what you asked.
yes, sir. Yes.
See, the informant is absconding, you are saying.
Yes, sir. Yes, sir.
And I would simplify your question. The informant does not want to appear or show up before the magistrate or before the police. He does not want to involve himself in the complications. I, being a Samaritan, good Samaritan, I simply inform the police that this offense has happened, and I don't want to be a witness.
Yes, sir.
Same situation, right?
Yes,
So police already has this kind of practice. They can record the FIR in self-statement, and they can proceed if they want to.
Yes, yes, sir.
Simple.
Yes.
Yes. Now see, this e-delivery or e-submitting of the police report has several objectives, and that's good also. It's convenient. Now what is happening, you have to supply the entire bulk of documents to the accused also, right? Now this provision says that supply of documents to the accused person electronically is sufficient compliance. So the portion that the prosecutor or the police wants to be removed from being given to the accused person, that may be removed and the e-copy may be simply transferred to the accused person by the magistrate. This is section 230. So 207-208 was there earlier. That is 230, one thing. Second, there is a timeline attached. Within 14 days, magistrates have to ensure that these documents are given to the accused person. Within 14 days, right? And this is sufficient compliance. One question I would like to ask. Police is filing the police report electronically. Let's assume that e-Sakshap is kept aside, right? Till then, what would happen? If, let's say, they are sending it through email, do they require a certificate of section 63? This is an e-copy, e-version of a digital record. This is a digital record filed before a court of law. Do we require certificate for digital record? No, we don't require. If it is an official ID, it is not required. That means whatever evidence is collected from the place of occurrence, a seizure document, let's say, whatever it is there, if it is sent through email to you, then there won't be any need of any certificate. Yes, sir? Otherwise, it is not required. That means police report is not considered as an evidence?
Can't be considered as evidence.
Right, okay, fine. See, there are certain questions which would surround this kind of situation. That police might come up, see, e-Sakshap is the future. It's not present, right? Until that is the present, these complications might be there that police might send the police report and other recordings which they have done in their mobile phone through their email, right? If they are doing it, obviously, unless that is considered as an evidence, that's true. The law also is very clear. Any document or any record which is produced before the court of law, if it is being considered as an evidence, then certificate is required. If it is not considered as an evidence, right. True. Physical file shall be submitted. Along with this, e-copy should be given. The physical file is still mandatory. But that problem of submitting multiple copies would be to an extent reduced. So please sit and ask.
Because it is from it was sent by a person. He is in custody of the said document. From 1/7 onwards, it doesn't require any certificate because it is a primary evidence. Because he is in the custody of those
Okay.
evidence.
Just to answer, okay, you are saying that once a document is coming from the custody of a rightful owner or rightful occupant, certificate is not required. No. If you go by the wording of section 63, this was their earlier provision. Now in the new law, 63 Evidence Act, just to clarify, two forms are given, Part A and Part B. Part A is to be given by whom? The occupant, the possessor, in every case. No primary, no secondary, in every case it is to be given. And Part B is to be given by an expert. Whatever record is submitted, you send it before the expert. Expert will analyze it and give the Part B certificate. Simple. So it is mandatory. It is not optional now, right? If we go by the wording, physical copy is still mandatory, including an electronic record. Including term, if we apply the rules of interpretation of statutes, including means inclusive. Including means inclusive. That means hard copy. Because see, if we make it, these people are not technological savvy. They are not so much able to understand things. Yes, If you interact with police officers, obviously you interact on a daily basis. Many of them do not know how to use mobile phones. So these problems are there. So which is why both e-copy would be used by the court to give it to the accused person. Hard copy is for the court. Nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report of 3 has been forwarded to the magistrate, and whereupon such of investigation, the officer in charge of police station obtains further evidence, oral, documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form as the state government may by rules provide. Provided that further investigation during trial, there is a difference. See, no, first provision, proviso 9 is subsection 8, but this new proviso is added, highlighted with yellow. So there is a difference in the scope. See, till now, under 173(8), police was doing investigation, filed the police report. Then they come across something new, or maybe they file police report just to disentitle the accused of the right of default bail. Yes or no? Under 167, there is a right to default bail. If within 90 days charge sheet is not filed, they might file just to disallow any right to default bail to the arrested person, right? Then at the same time, they require certain time to investigate on further issues and then file the conclusive or supplementary charge sheet. So which is there in subsection 9. This proviso is allowing investigation, further investigation during trial. It is after cognizance. Yes, after framing of charges, trial commences. So the scope is different. First subsection 9 is talking about investigation before cognizance. And there have been judgments also on this point. Once the police files the police report to the magistrate, just to clarify on subsection 1 and subsection on this proviso. If you scrutinize the entire jurisprudence that has evolved through judicial decisions, police, if they file the police report with the magistrate, investigation ends. They can't investigate. But if they want to investigate, they may investigate with the permission of the court, right? So they have to inform you. If they conduct investigation without your permission and the moment you take cognizance, investigation is of no use. Huh? No, permission is not mandatory from the court. Same thing. Same thing. So what is the purpose behind it? The purpose is, if you are being informed that police is further investigating the case, you would not take cognizance. Because if you take cognizance, that person can't file the police report, additional charge sheet. Yes, that's what I'm answering. Okay, let me simplify it. I am a police officer. Okay? I file a police report before you, right? The moment I file the police report, investigation stops. Or it is filed only after the stoppage of investigation, right? Now suddenly I realize that there are a few points which need to be investigated. Should I start investigation on my own? No. Because why so? I start with an investigation and you take cognizance, then I can't file the supplement because it ends there. I do not have power to do that, right? So there have been judgments which says that if you want to do the further investigation, inform magistrate of the same. So till the time you are conducting investigation, further investigation, magistrate would not take cognizance. They'll wait for the filing of the supplementary charge sheet. This is the law. This has been the law till now, right? Sir, true, you are right. This. Okay. Okay, let me add on something. Provision 173 never mentioned about this. Provision 73, 173 never mentioned about this, but there are judgments from Supreme Court which mention this thing. But this was not practiced. In many of the courts, it was not practiced. But there are judgments suggesting that if police wants to conduct further investigation, they should first inform the magistrate, then only proceed with further investigation, otherwise not. Right? This is there. Second, now if I file the police report, investigation stops. Proviso is added, there could be a possibility that new evidences might crop up. Right? New people might be involved in the commission of crime and the person might confess before the court of law for several reasons, you all know that. Then investigation may be required. This is talking about that further investigation during the pendency of trial. And this should be done, 1 second sir, and this should be done, timeline is prescribed within 90 days, which may be extended with the permission of the court. True, this could be one situation, but this is one situation, not an interpretation, sir. Reason being, this is talking about a trial stage. This is not talking about cognizance or inquiry. Trial commences with the framing of the charges. You all would agree with this? Till the stage of framing of charge, inquiry is happening. This is mentioning trial. That means even during trial, you may ask the police to investigate the case. True. I did not get you, please. Huh? During the trial, yes. Yes, that's what I'm saying. I'm saying the same thing. Yes, yes, that's what I'm saying. That's the same thing I'm saying. After the trial has commenced, if the police has to conduct investigation or magistrate wants the police to do something, this 90 days time is there. Am I clear or some confusion is still there? No? Okay. Okay, suicide. Here I would.
This discussion is going on because earlier 178, so several applications came to file. Even complaints had also filed applications in the direct and so the High Court told further investigation. So in such circumstances, contention that court has no power to direct the further everything for the IO only, investigation only. So moto it proceed. So we face these type of situations.
There's a difference of opinion. Yeah, I understand. I understand. See, that's the thing. That's why the law is now again mentioning specifically. Many things that came through judgments, and which does not form part of the statute book. This is the problem. Now, again, I would like to take you to some forensic science concepts, if you are willing. Okay. Again, cases of suicide and unnatural deaths. Suicide, it is mentioning suicide, wherein some person is killed by another person. So there could be chances of homicidal death, accidental death, or suicide. 3 situations: suicide, homicide, or accidental death. If we take the opinion from a forensic expert, in these 3 situations, we can easily identify by conducting the postmortem, and you all would be knowing it, that the observations, internal observations as well as external observations, both are different, right? In a case of hanging, we classify hanging into several types: typical hanging, atypical hanging, complete hanging, and partial hanging. So in every situation, the position of the body, 1, 2, the placing of the knot would be different. And in every case, see, if we are talking about only suicide or death by hanging, suicide is death by hanging I am referring to, one situation. In death by hanging, the major causes of death are death from asphyxia. Asphyxia relates to stoppage of inhaling of oxygen and exhaling of carbon dioxide, right? One thing. 2, when the neck is compressed, what is happening? There is a pressure being exerted on hyoid bone. There is a pressure being exerted on the jugular vein, right? Leading to 2 situations. When jugular vein is being compressed, it would stop the flow of oxygenated blood to the brain, leading to what? Cerebral ischemia. That means absence of blood in the brain. This is 1. 2, when this hyoid bone is being pressed and the weight of the body, considering the weight of the body, right, it would fracture. Third thing, if the body is completely suspended, so I talked about 4 situations: complete hanging, partial hanging, typical and atypical. When the body is completely suspended and a lot of pressure is being exerted on the cervical vertebrae, so either it would be dislocated or it would be fractured, right? So what is happening? Cerebral ischemia, asphyxia, stoppage of oxygen. 3, fracture of hyoid bone, and 4, dislocation of the cervical vertebrae. There could be a possibility that someone is suffocated to death and then hanged. Would it break? Less possibility. There is less possibility. Then some forensic observations. If a person is hanged alive, then what would happen? External observations only. We are not going into the forensic thing. The head would be inclined in the opposite direction of the knot. Yes or no? If knot is placed on this side, pulled upwards, head would be tilted towards the opposite side. And in the angle in which the head is tilted, saliva and bloody froth would be dribbling from the mouth. This is one peculiar observation. If he was first hanged, if he was first killed and then hanged, then this would not happen. Why so? Because once a person is dead, saliva formation would stop. So these are basic forensic observations which, if we involve as part of the investigation team, as part of the prosecution or trial, we can definitely arrive at a narrowed and specific conclusion, right? Likewise, if I refer to cases of homicide or suicide, so we may look into the that's why, see, it is said when a forensic investigation is being done, they should also record the video as the point of entry and the point of exit. Both should be recorded. And the entire area should also be recorded, so as to allow the court to see how many entries were there to that room, how many exits were there, right? Then if, let's say, a window has been used to enter the place, enter the room, what is the height of that building? So these would allow the court to look into the possibilities and the impossibilities. 20-30 floor building, it is difficult to enter through window. It is difficult, right? It's a circumstantial evidence, but again it is difficult. But again, at the same time, circumstantial evidences also have its own limitations. There have been English cases also wherein a person is found dead in his place. The servant who was living with that lady, old lady was there, she was found dead. He was prosecuted and convicted, reason being, nobody could have had the opportunity to enter the room because the gate was locked from outside, only window was opened, and it was a high-rise building. How is it possible for someone to enter and kill that lady? After the servant was prosecuted, convicted, and given death sentence also. Later on, somehow it came to the knowledge of the court that someone placed a ladder from a parallel building, entered the window, through the window, executed the crime, and retreated. Because no forensic investigation was applied in this case, this is the result. If they would have applied forensic investigation, possibilities of, as I said, chance evidences are there. possibilities of collecting chance evidences. Latent prints can be recovered. Latent prints are those prints which are not visible from naked eyes. You need to develop it with the help of some powdered solution or something like that. Experts can do that, right? So same thing is here also. If you talk about suicide, homicide, accidental death, all these things can be easily collected, easily narrowed down by the investigators if they take the help of forensic team, and inquest is done at the earliest. Few precautions need to be kept. Like recently, one incident happened. I'm coming from Jharkhand. There is one place, Bokaro Tata Steel, Tata place is there. No, Bokaro Steel Plant is there. One tragedy happened within the premises. Now, factory people would never want to give a compensatory employment to anyone. So they would not want it to appear as a death caused during the course of employment. They would try to give it a shape of natural death. Someone dies of natural death, company is not liable. Simple, right? Immediately after death, remove the dead body and it got cremated without conducting the inquest. Or even, so which is why certain protocols are there, that you cannot touch the body before recording the place of occurrence. Videography is mandatory, recording what wounds are there lying available on the body, any other incriminating object that might be placed near the body, like that. Then when the body is collected, taken to the place wherein postmortem is to be done, it safely should be recorded, every wound should be recorded, place details should be mentioned. All those things, documentation is required to be sure that whether it is homicide, accident, or a case of suicide, right? So this needs to be looked upon. Then again a timeline is added that the report shall be submitted to within 24 hours. The report shall be signed by such police officer and other person, or by so many of them as concur therein, and shall be forwarded to the district magistrate or sub-divisional magistrate within 24 hours. This is new timeline added. Otherwise the provision is same, there is no change. Power to issue summons by police. Now, few things are there, like male person below 15 years, above 16 years, or a woman or mentally, physically disabled person, or a person with acute illness shall be required to attend at any place other than the place where such person resides. Provided further that if such person is willing to attend and answer to the police station, that such person may be permitted to do so. So this is simple. If that person wants to come, that person may be allowed. Inquiry by magistrate, the law is same herein. See, magistrate. Earlier it was judicial magistrate, now it is magistrate or executive magistrates. So this clarifies, magistrate means judicial magistrate only. Now, this is all about investigation. If you have any questions with respect to this, we may take up for 5 minutes, then I'll proceed with arrest and summons and warrant. Any question? Should I proceed? Okay. Now, provisions contained in section 41 and 41A CRPC, they have been merged to section 35. Now, section 35 is the whole soul Bible of the arrest norms. Okay, the law is same, there is no change, only small change is there. I'll bring it directly to that small change. Yeah. See, no arrest shall be made without permission, prior permission of an officer not below the rank of DSP in case of an offence which is punishable for imprisonment of less than 3 years and such person is infirm or is above 60 years of age. Do you get the point? Any offence in which the imprisonment is less than 3 years and that person is an infirm, that person shall not be arrested. Besides this, if a person is above 60 years of age, he shall not be arrested without the prior permission of Deputy Superintendent of Police. So same thing as I mentioned, the format is there. You have to take written consent. Oral consent does not qualify at all. And then it needs to be submitted along with the arrest memo, right? A few safeguards are there. There is no change in it in general. A person to be arrested should be informed of the grounds of arrest, right? Person should be arrested should be informed of the right to bail. Then any person, like family member, should be informed of the place where this person would be taken, right? If family member is not available, then any person who is nominated by this arrestee shall be informed of the place and the grounds and everything of the person where he would be kept, like that, okay? Only these two. Only these two. Person above 60 years of age, one, and second, where punishment is 3 years and person is infirm, right? Then prior permission of DSP. Then section 41D is now section 38. He shall be entitled to meet an advocate of his own choice during interrogation, though not throughout the interrogation. Provision is same, there is no change. Arrest on refusal to give name, same. Section 43 is now section 40, there is no change. Arrest how made, here one change is there. Handcuffing is allowed in certain offences. Through Prem Shankar Shukla, it was done away with. Now, they have mentioned specific cases. Habitual offender or repeat offender, or who escaped from custody, or who has committed offence of organized crime, terrorist act, drug-related crime, or illegal possession of arms and ammunition, murder, rape, acid attack, counterfeiting of coins and currency notes, human trafficking, sexual offences against child, or offence against the state. Now, sexual offence against child, not sexual assault. That means all offences within POCSO are covered within this section. Handcuffing may be done, right? Then section 44 is there is no change in it. I am not dealing with these sections. I am skipped, otherwise we won't be able to complete. So I am just referring to the sections wherein changes have been introduced, right? This heading is now rephrased a little bit. It mentions obligation of person making arrest to inform about arrest to relative or friend. The same. Search of arrested person. Power to seize offensive weapons. This section is interesting. If you read the wordings, the police officer or other person making an arrest under this Sanhita may immediately after the arrest is made take from the person arrested any offensive weapon which he has about his person. Immediately after making the arrest, seize the weapon. Would he allow to arrest him if he has the possession of an offensive weapon? No, he will not allow, right? So this line makes no sense. In simple terms, you have to take it and then arrest it, or disarm him first before making the arrest. So this is interesting, but it is part of the law, but practically not possible. Section 51, examination of accused by medical practitioner. Law is same, there is no change. Yeah, here it is. Examination of arrested person by a medical officer. Provided that if the medical officer or the registered medical practitioner is of the opinion that one more examination of such person is necessary, he may do so. Now this provision is allowing for multiple medical examinations by the medical practitioner, and after first examination they might mention specifically that how many sittings they want. So this provision is there. But again, there are certain gaps which I have mentioned, when those examinations need to be done, where they need to be done, and what would be the scope of that examination, right? This law does not clarify. Even the rules, whatever little rules that have come from the BPRD and NCRB, they also do not mention about this thing. Yes, sir. law is silent on this. Lies silent on this. It is now telling the medical expert who is conducting examination to mention when. Huh. Yes, true. So there could be a possibility that the expert might not be satisfied in one sitting. This is what is the implication of law. He might not be satisfied in one sitting. He may ask for more sittings of examination. That is what it is mentioning. But your question is not answered here in the law. It does not mention about it. Yeah. Identification of arrested person. Here it is mandated that at the time of identification parade, audio, video, electronic means should be used for the purpose of recording the TIP, right? Can TIP be conducted through a photograph, or physical presence is necessary? Physical presence is necessary. That means there can't be any identification parade with the help of a photograph. That can't be. This question was addressed by Supreme Court in any judgment? Anyone? Manu Sharma only. Manu Sharma says State and City of Delhi. Jessica Lal murder case only. Police got the photograph. Now they want to conduct identification parade with the help of photograph. It is generally not allowed. But the question is still left open. There is no concrete answer, conclusive answer to this question. Depending on situations, there could be a possibility that court might permit identification with the help of a photograph. But that needs a lot of supervision. If the that's why Manu Sharma judgment, that's the same thing. This person was not ready to surrender. So police conduct this search in the house, they get photograph, what they do. So they may use that photograph for the purpose of identification. This is what the fundamental question is before the court of law. So identification can be established, but that can't have the same evidentiary value as that of a TIP, which is done by police and magistrate under this section. The evidentiary value would vary. Yes, person arrested shall be produced before magistrate within 24 hours, whether having jurisdiction or not. That means, in simple terms, any magistrate can, yes, before them a person arrested can be taken. Arrest shall be made strictly according to Sanhita. Summons, little changes here. Summons. Arrest, there is no change, just one. People above 60 years of age, punishment less than 3 years, person is infirm. Right. Now see, this electronic delivery of summons is now the rule of law. In an encrypted, see, every summon issued by a court under this Sanhita shall be in writing in duplicate, signed by the presiding officer of such court or by such another officer as the High Court may from time to time by rule direct, and shall bear the seal of the court. Simple. Or in an encrypted or any other form of electronic communication, and shall bear the image of the seal of the court or digital signature. You all understand digital signature? You understand that is permissible under IT Act and that is being used widely now. This electronic delivery of summon is also permissible now, and how it will be served? See, police, provided that the police station or the registrar of the court, this is important for you, registrar of the court shall maintain a register to enter the address, email address, phone number and other such other details as the state government may by rules provide. So these rules are still pending. This register is to be maintained, this is clear, right? What details should be mentioned? Phone number, WhatsApp number may also be there. If there is a Telegram account, that may also be there. Text message, email, everything that can be exercised. Second, provided the summons bearing the image of court seal may also be served by electronic communication in such form and in such manner as the state government may by rules provide. Because the first line says the summons shall, if practicable, be served personally on the person summoned by delivering or tendering to him one of the duplicates of the summons, right? So still the first preference would be given to the physical delivery of summons, right? If that is not practically be possible, person is evading the delivery of summon, then this mechanism may be adopted and a copy may be sent to his mobile phone. It may also happen that if with future, with time, that these records will be developed, directly sent to the mobile phone or the email. At the same time, hard copy also may be dispatched. Same thing. At the same time, every method can be exhausted at the same time, right? Now, initially it was mentioned adult male member. Now it is replaced with adult member, male or female, both. But he should be a family member. He or she should be a family member, and servant does not qualify as a family member. Simple. Can a child be delivered a summon? No. It should be an adult. Yes. Again, this clause is added, subsection 3. All summons served through electronic communication under 64 to 71 shall be considered as duly served, and a copy of such summons shall be attested and kept as a proof of service of summon. Served through electronic means if you have sent it through email, take a printout. If you send through other electronic means, take a printout of that, attest it, and keep a record of that. And what I am talking about, if this eSaksh app might be further developed, and an option may be added of the delivery of summons. You click it, attach the mobile number, details of the witnesses and arrestee, everything. At one place only, it can be easily delivered. And this is being tested on a trial basis. This text thing, what I was referring to, that as a text message, you can attach the link of the summon and send on the mobile phone. That person may click on the link. He would be directed to the website where summon would automatically get opened, and he would be presumed to have received the summon copy, right? Again, same thing, served by notwithstanding anything contained in the preceding chapter, a court issuing a summon to a witness may, in addition to and simultaneously with the issue of such summons, direct a copy of the summons to be served by electronic communication. See, simultaneously. So both hard copy and soft copy may be simultaneously served on proof of delivery of summons by electronic communication. So you keep the record that is there, nothing new. Warrant. Warrant in warrant cases also, warrant may be created or generated electronically, but warrant can't be executed electronically. For this, you need physical intervention. So law is permitting e-warrants now, e-summons and e-warrants. But e-warrants need to be executed by someone physically, right? So this provision is same. Warrants to whom directed, this is there. Warrants to be directed to any person. Any place in India. Warrant forwarded for execution outside jurisdiction. Warrant directed to police officer. Yeah. Procedure on arrest of person against whom warrant is issued. On the arrest of any person referred to in subsection 1, the police officer shall forthwith give the information regarding such arrest and place where the arrested person is being held to the designated police officer in the district and to such officer of another district where the arrested person normally resides. This is one new thing added under 82. This is again same, there is no change. One change is brought which made punishable. See, where a proclamation punishable published under 1 is in respect of person accused of an offence which is made punishable with imprisonment of 10 years or more or with death under the Bharatiya Nyaya Sanhita or under any other law for the time being in force. This is now a little explained, that's it. There is no change as such in it. And this person may be declared as proclaimed offender. Identification and attachment of, I think that was there, I missed that slide, wherein e-warrants is mentioned, that e-warrants may be issued, but obviously it needs to be executed by a person. Identification and attachment, this is a new provision added, section 86. How much time do we have now? With 10 minutes. So I'll not take up a new topic. This was with respect to arrest, investigation, summon and warrant. New topic I'll take tomorrow. If you have any question around the topics that we have discussed, we may just clarify those questions now instead of moving on to a new topic. Yes, sir. That is already there in subsection 9.
Yeah,
Trial has not commenced, police is conducting investigation.
they can, at any time it can be. But if the trial is commenced, then only
Then 90 days.
What is the in fact of the intention of the lawmakers?
Simple thing. See, generally, police is asked to conduct investigation within 90 days when the punishment is 10 years or above.
Yeah,
But that is also not mandatory. That is also not mandatory. If police conducts investigation even after that, person will only get the right to default bail. That's it. Yes. That means there is no timeline prescribed under the law for completing investigation, right? Till the stage of cognizance, same thing applies.
number of charge sheet can be filed.
No. Yes, you conduct further investigation, you file supplementary charge sheet.
So till that filing the charge sheet, trial is commenced, number of charge sheet can be filed.
No. After trial has commenced, you have to take permission from court because the proviso is added.
So kindly my question is that, sir, till the trial is commenced, number of charge sheet can be filed, sir?
With the permission of court?
Okay, sir, one thing. Second is that, sir, during the trial, if the trial is commenced, one time additional charge sheet can be submitted within 90 days. Okay, over. Sir, again trial is commenced. Again permission can be taken to file the second additional charge sheet?
Again trial means the trial is still continuing, no? The trial is still continuing. You may take permission from the court, investigate, file charge sheet within 90 days. This 90 days may be further extended. This 90 days may be further extended with the permission of the court.
Again, sir.
Again,
time,
yes.
Second time, third time, like that.
Yes. Later it is.
Yes. If they feel
90 days, take permission, get an extension, then file, not a problem. But if you, take your question further, if you're saying that you may take multiple requests, no, that may not be allowed. Court may not, see, provision is not saying it. We'll assume it to be once only.
no.
Huh.
No. There is no wording used there stating that further investigation, if any, shall be done only once. Even after completion of the further investigation once, if IO feels there are some more materials to be collected under further investigation, he can proceed with the permission
That's what he's
from
saying,
court.
with the permission of court.
Court.
Huh. So court has to form an opinion with respect to the same thing. If the court is convinced that further investigation is required, court may direct. Court may direct. But at the same time, see, one thing I want to add, if you are making multiple requests, court has to be a little cautious. Court has to be a little cautious. And multiple requests, as a rule of prudence, should not be permitted because that person might be planting some evidences outside. This could be a possibility.
If in the opinion of court, further investigation is not necessary, then court can reject the request of the IO.
I can't see you. Okay.
If court feels that further investigation is not required in the case, then request of the investigating officer can be rejected by the court.
Yes.
Court is at discretion.
Definitely. Definitely. Because here it is simply saying you have to get the permission from court. Any other question, any other topic? Tomorrow we'll talk about this thing, summon trial, warrant trial, timelines which have been prescribed, cognizance and beyond.
It is only within the knowledge of the IO only. Sir.
IO only. True. See,
The
both
application is rejected.
everything has both the sides. It is also possible. See, how I perceive a criminal case is, it is only the victim and the accused who knows that whether a crime has taken place or not. Everybody else is trying to find out the same thing, but they actually know it, right? So this may be interpreted to mean that wherein an allegation is made by any victim, we should proceed upon that? No, but that does not happen. We have to check whether he's right, he's wrong, whether he's lying or not. Likewise, IO makes a request. We might think that he is the one who knows things in a better way, but that does not give a general presumption that every IO would be acting with utmost honesty. So things need to be analyzed and assessed before granting any kind of permission, because the trial has already commenced. Any other question? Okay, thank you.
Thank you, sir, for that detailed and comprehensive session on BNSS. Let's continue the other parts of BNSS tomorrow. By this, we will conclude the second day of training. High tea is arranged at first floor and third floor. Kindly join us, and we will see tomorrow. Thank you all.